Maybe little lost.
Just a moment. Mr. Goswami. Mr. Goswami. In that matter, just give us the file. It was CGC is not there. Mr. Arkady Chaudhary. Oh, you are there? That will do.
Yes, Lordship.
Please say this.
Yes.
Kindly come over to this side so that Mr. Goswami can also look into it. Come over to this side. It will be easier for both of you to look into the file. You see the second page. This is a calculation. No, the second page of in your hand. Second page. Yes. Second page. Now you see, look at the calculation of delay. Correct. Now 21 is not even given. So there is, you see, from 2018 to 22 is 4 years, taking 350 days in a year for easy calculation. It is 1400 days. So here the calculation is 900 days given by the registry, and therefore in the affidavit it is 920 days given. But there's a mistake. There's an error of not giving the calculation of entire year.
Yes.
From 21, there's no explanation. So that is a mistake committed by the registry, and therefore in that gap, 920 days is written. Please inform Mr. Arkady Chaudhary. You will have to do something more now. Because what has happened when I call the registry to find out what has happened, then we came to know that during that, because of that judgment in Suomoto 3,
Yes.
by the Supreme Court, they have omitted the calculation itself. But here the limitations started earlier.
Start from the date of the disposal of the.
No, that's why they made a mistake. But
I have not seen. I don't.
no, because while you are there, please come over to this side. Now you see here, look at this page 2. Here, when the calculation was made, they have omitted 21. 18 to 22 is 4 years. So it should be more than 1400 days. Correct. So that 21 was had been taken away. So we called the people in the registry to ask what has happened. They made an inquiry and told us that because of the judgment of Supreme Court in this Suomoto 3, they omitted the calculation of that COVID period. But that can't be done.
No.
But since it's the mistake of the registry where they made the calculation of 920 days, which made a corresponding error in your affidavit, I think you'll have to do something more. Huh?
I have gone by there.
No, because naturally,
That was good enough for me.
I do this cross-checking.
I never can do that.
No, it's not necessary. Even I don't know what happened, why it struck me to have this calculation, because 900 days doesn't make the calculation.
Sir, yeah, senior lordship has been very immaculate in.
No. It's you see, just a connect. Otherwise, we are disconnected. We don't have this reason to make that calculation. But 18 to 22, why it can be 900 days?
Fully lordship. But now that it has come to your lordship's notice, lordship, Is your
Because it
lordship-
doesn't matter to you whether it is 900 or 1400 now.
I-20 is bad enough for me. Considering the expenditure.
But do it because this is a mistake of the registry. We won't take so much of it.
Yeah.
That 300 days, but you'll have to do something more.
But
We, we'll adjourn the matter because I couldn't deliver the
yes,
order on that day.
lordship.
I don't know what happened, what made me look into that.
The number of years possibly struck
But-
your lordship.
Means 3 years, 4 years can't be 900 days.
So
And therefore, this calculation.
perhaps in another court it would have gone.
We don't know. We don't know. We can't comment. We can't comment on anything except
I
what we do
I
here.
did not notice it. Sir also did not notice
I
it.
don't calculate. You are saying 920 days, that is.
Good enough.
That is what the registry has put in, lordship.
And for the petition and for the respondent, it is bad enough. Okay, so we just say that we just say heard Mr. Architect Chaudhary and counsel, it's the DSGI appearing for the the applicant and Mr. P.K. Goswami, learned senior counsel, assisted by Mr. S.K. Dekar, learned counsel for the respondent. Next para. The matter was heard on DPO yesterday. It was 12/20/24. First of, however, while detailing the orders in the chamber, it appears that there is some error in the calculation of delay. First of, the same is so accordingly the order could not be passed, and the matter was listed at the instead of the instance of the court today. Next para, the learned DSGI, the learned DSGI as well as the learned senior counsel for the respondent has seen the calculation. Full stop. Accordingly, the learned DSGI has prayed for some time to take necessary steps. Full stop. Accordingly, matter stands adjourned today. List on.
Let it be after the vacation, lordship.
Okay, we'll give a fixed date, Mr. Goswami. You
Any day convenient.
Okay. Uh,
uh, 6th or 8th of January, Mr. Goswami, what would be
it's
convenient?
fine. Lordship, I just wanted to know, lordship, am I required to file an additional affidavit to?
You
Or
take your call because
it's something,
that is something
perhaps it can be
that
corrected
is
in the registry also.
that is something which I left there.
Perhaps it can be corrected in the office also. It's,
We don't know. We don't know.
When you have stated that to be the.
lordship,
But knowing Mr. Goswami, it would be fair enough to you at least. I think so. For these
lordship,
questions.
lordship.
List on 6th or 8th, when? 6th is a Monday and 8th is a Wednesday.
Let it be on 8th, lordship. Let it be on 8th.
8/1/2024.
Wednesday.
Okay.
जो भी affidavit available है,
And similar thing, there was one matter yesterday at item 20. Anybody is there for that item? Mr. A.K. Agarwala had argued. You're there? Item 20?
Yes, sir.
In your case, I'll in fact, I here also I am amazed what happened. There's a difference in the name in the affidavit and in the cost title. We couldn't pass an order. It'll be listed some other day. Now look at the nature of corrections we have to see. We have to now not only doubt the petitioner who is a foreigner, we have to even cross-check the names from the cost title, then check up the affidavit and then find out if that is what I have to do.
Apologize, your lordship, there must be some mistake. I'll just.
But you see, after drafting, before filing, at least you have to check something.
Yes, sir. I see.
Why should we undertake that task of comparing the names in the cost title and in the affidavit and then find out that something is wrong? And you must think
deeply
that
regret
the
your loss.
amount of energy we spent on all these things,
I deeply regret your loss. I must apologize.
and it is absolutely a thankless job. You just say sorry and then end of the matter, and we end up working late in the night, the entire staff finding out what has happened. Okay. Yesterday that order was not passed. We will be listing the matter someday else.
I get to mention for listing, my lord.
Listing give it to the court master.
Yes, sir.
May I please, your lordship? Also, back to mention item number 23 of the daily list, your lordship. Lordship, kindly pass over for a day, your lordship.
It goes after vacation because we can't accommodate these days.
Okay, yes.
May it please your lordship.
After vacation, item 23 is paid for by land council to the petitioner. 23,
Yes, your lordship.
yes.
May it please your lordship.
Obliged.
I got to mention item number 24 and 26. Matter will come on after vacation, my lord. 24 and 26.
Same order. 24, 25,
26, my lord. 24 and 26.
24 and 26.
Obliged.
Late legal loss. I have to mention item number 17. Kindly pass over for the case.
17, there's an adjournment slip.
My lord.
Okay, item 17, after vacation. Item 17.
Obliged.
Please, your lordship. Item 20, lordship. I am on behalf of Jesse Gogoi, lordship. He is not well, lordship. So, madam, I will pass over for a day, lordship. 20, 20.
20 after vacation.
Obliged.
Yes,
May I please, Lordship, in regard item number 43, Your Lordship, little accommodation, Your Lordship, can it be taken at 2 p.m., Your Lordship?
23, we don't know, we can take it up because
This review
it's
petition.
a review petition.
Yes.
We'll try to see, but we can't assure you right now. At the last, we'll try to see.
Obliged.
May I please, lordship. Item number 21, my lord. Let me pass over for the day, my lord.
Video no, same after vacation.
Yes, my lord.
Lordship, item number 5 and 22. Pass over the matter for the day. The scenario is out of.
5 and
5 and 22. Lordship.
20,
22.
5 and 22, lordship.
5 and 22. Okay, after vacation.
May I please, your lordship? Lordship, may I, lordship, item number 15, kindly pass over the
Item
15, 1-5.
Okay.
Obliged, your lordship.
May I please, your lordship. Lordship, I beg to mention item number 39, lordship. Lordship, earlier occasions matter was not reached, lordship. Petitioner is in detention camp, lordship. Can it be taken at 2, lordship?
We'll try to, but we can't say. We are making a note. Try to take up.
Lordship.
Yes.
May I please, your lordship. Lordship, I beg to mention item number 30, lordship. Adjourn for the day, lordship.
13, 1-3,
3030.
30. 21. Okay. Hello.
Daily list item 1 for motion.
May I please, your lordship. My lord.
What is the explanation of the delay?
My lord, page 1326 para.
Page number
Page 13, my lord.
13.
Para 26. My lord,
48, my lord.
48 minutes. But my lord, kindly see the deposition of my lord DW4, my.
You say that your grandfather had property, then you separately say that your father had property. If your father and grandfather had property, number one, the statement you are showing us that you are poor is false statement.
My lord, in a village, only some portion of
We
land
don't know.
are there, my lord.
Don't tell us about those things. This is something which is not even pleaded. That was found out only on reading of the evidence. So therefore, you don't have a case at all. Opinion dated page 48. 38/2022. Passed by so and so and so and so. Has not all reference to notice extra copies within 2 days. Bail. Default clause. List after 4 weeks on receipt of reports of tribunal.
My lord, interim.
Queen bail 5,000 to the satisfaction of SP border.
No count.
No wrong.
Within how many days, my lord?
10 days.
10. Obliged, my lord.
Item 2 for motion.
May I please, my lord? My lord? My lord, petitioner, is it about 66 years? my lord?
Just a moment. Which page is the opinion?
Opinion is 57, my lord.
Item only no. Oh, PL 40, item 46, no? Yes, sir. Oh, not Simon, but I will say, no. Item Mario. Eight one.
Where is the voter list where you have voted with your father?
My father, along with my father, my lord petitioner. Along with my father, no voter list, my lord.
Hmm?
Cast vote along with petitioner's name, not enrolled along with his father, my lord.
You are not also there with your brothers. That is the finding of the tribunal.
Yes, my lord. It's start from page 20, my lord. This is the 1966 voter list, my father's name, my lord.
You have many siblings,
My lord.
but you are out of the family. So it's a manufactured case. Who are the witnesses who came to depose for you?
Only my lord petitioner himself, my lord.
That Mr. K.M. Hassan, from Council for the Tribunal. As Barwal and SAC for respondent number 1. Mr. H. Kuli on behalf of Ms. AIL for respondent number 2. Mr. J. Pang, standing counsel for the FT matters, presenting respondent 3, 4, 5, and 7, and Mr. T. Sharma, additional senior government advocate for respondent number 6. Opinion dated page 57. 24/1/2024. passed by so and so in so and so. Arising out of reference case number so and so. By which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Similar bail to the satisfaction of SP Border Morigaon. Obviously.
Item 3,
Map.
What is the explanation of delay?
Let me kindly come to para 16, my lord. Yes,
No, but your statement is false. You have land and then you say you have property. Can't be believed. You have to file a better affidavit. You can't entertain a false statement.
my lord, petitioner doesn't have, my lord, landed property, my lord. Her grandfather had, my lord.
Yeah, have you read your brief? Have you read your brief before you start arguing? Have you read your brief? Come to your synopsis. Last two lines, the land has been mutated in a name.
Yes.
Mr.
After death of
J.
her father,
Islam, learned counsel for the petitioner, has submitted that the petitioner does not have a land and she is poor, which appears to be contradictory to the stand taken in the affidavit, in the synopsis, where the petitioner asserts that the land is mutated in her name. So accordingly, it appears that the statement made in the writ petition is false if the statement of the counsel is correct. Full stop. Accordingly, the court is disinclined to take up the matter unless a clarificatory affidavit is filed by the petitioner. Mr. Matter stands adjourned today. Yes, all the respondents are represented. List as and when the additional affidavit is filed.
item 4,
You must not have an impression that the court is come unprepared. Never
but
do it.
it was, my lord, in
Never do it.
23,
Never do it.
always.
Yes, what is your explanation for the delay?
At page 24, 33.
Page 24.
Pair
Raja?
33, pair 33.
No, that is false. Again, you also have land.
Yes, your lordship, that land has been inherited by my father and we share the land. There are a lot of with my siblings.
No, but if you have land, how can you say that you are poor?
Your lordship, in a rural, may I just request your lordship, in rural place, the land has been inherited from my father. If that land, it doesn't count, it doesn't have any value to it, attached to it. I am a poor woman, housewife. So that's my condition, your lordship. And your lordship, in this case, my sister has been declared an Indian. She has also come and deposed before the tribunal. And the same tribunal, in my case, declares me as a foreigner. So on the merits, your lordship, I have a very strong case. And there is also a linkage with Jamabandi.
No, that is the whole issue. If you have land, how can you be poor?
Your lordship is absolutely right.
There is a statement in the to explain that 33.
Yes, sir.
You see, your explanations which you give does not inspire any confidence. You see, you take certain plea which looks good when you write. When you write this Latin proverbs, lex non condicia impossiblia, it looks very good. But have you applied the law? In the state of Assam, there is a facility that if you want a death certificate, you'll have to apply before the deputy commissioner. He gives an order if you can explain the delay. So you say that it is impossible. How it is impossible to get a death certificate even after several years? Sitting in this bench, we have seen even after 40 years, people are taking out the death certificate or birth certificate. It's a question of satisfaction. Under the Registration of Births and Deaths Act, there's a provision where you can apply. So why do you write these things which catch the eye? And we'll have to tell us that what steps you took under that act and put you to more difficulty. Because you must come with clean hands. If you make out a story, you must know how to make out a story. You say you are otherwise even since you have been declared to be a foreigner, you must come with more better hands. You write these things and then you make trouble for yourself. Now, if we come to know that the state is not acting in accordance with law, we are required to take cognizance of that also. A division bench taking up the matter can't let that escape. Then, what steps you took? When did you apply? When did you not get? What is the explanation to those things? You write one thing extra and we catch that only. Did you apply? Have you made a statement that you applied before the deputy commissioner under the Assam Registration Birth of Acts Deaths rules?
No,
Then
sir,
why do you make that statement? You withdraw it.
so that may I submit just on that regard, Your Lordship? That argument is only with respect to the constitutional argument that we are making, with respect that why can't I prove my citizenship by birth? Because Your Lordship will know that if I have to prove my citizenship by birth, I'll need at least some certificate. So my only concern is that since I come from a poor background, I didn't apply
Yes.
for that, and that's the reason I can't.
No, your citizenship is doubtful. The state considers you to be a person who has entered into Assam
Illegally.
from Bangladesh. You
Yes,
can't be permitted unless you show us some document.
But
And therefore, for the registration, the fact remains that you have to take steps.
apart from that, my sister has been.
So those are
She
things
has-
separate, but you withdraw this statement. If you have not applied for, you withdraw this statement.
We do.
Can't permit a false statement because you see, you must come with clean hands. One false statement is good enough for us to dismiss your reputation in limine.
We are, well, we are not making any statement that is contrary, Your Lordship. We only say that
If you don't apply, how will you get it?
We
How do you justify this statement? Law does not demand the impossible. We are not demanding anything impossible. This was never a thought. But now when you pen it down, then we ask that question. This never came to our mind. We never had this idea. Now you've given us an idea and therefore you please sustain. How do you say that?
if notice can be issued, my lords, LCR
We
may
withdraw this statement because if this we saw, this is the only ground we are dismissing it. Anything and everything can't be written. And that will not permit. Was this ground taken before the tribunal?
On the citizenship by birth status, yes, Your Lordship.
No. That the steps that you did not get the birth certificate and therefore was that ground taken in the tribunal? Where is the discussion on that in the opinion?
Your Lordship, written statement, my lords, kindly come to page 40.
Yes.
Para 3, Your Lordship, is a bona fide citizen of India by birth.
No. That's not.
So we have taken that ground that, Your Lordship,
No.
If
This
I
plea
may-
was. You see, this plea was never urged.
if I may, Your Lordship, if I may, my only, we have been trying, why we made this as a ground is that, Your Lordship, in under 6A, I only have to prove my residency. I don't have to prove my citizenship by birth. Citizenship by birth, I have to prove when, under Citizenship Act, that's a different section 3 provision. Now, both two, under 6A, I have to show only my residency 71, in which Your Lordship has been
You see,
taking.
you are making a statement. We are not asking you why you have written that. You have made a statement that the law does not demand an impossible. The question to you is, under the Assam Births and Deaths Registration rules, there is a provision to apply before the Deputy Commissioner and to get it. Have you done it?
So allow me to file an additional affidavit on
To
that.
do it because this every statement will not accept.
Allow me.
Because it has become a difficult situation. The pleadings, every day we are finding out fault with the pleadings, the nature of statement being made. Something must stop somewhere.
Allow us to file additional affidavit, Your Lordship.
In your case yesterday, you see, do you think it's a fun for us? We read the cost title, we read the affidavit and find out that your name is wrong. Therefore, we are not allowing everything to be written down. If you write anything which is not a part of we are exercising certiorari jurisdiction. We will only take up those matters to find out those pleadings made in the writ petition to find out whether the decision of the tribunal was incorrect. Because we are not, this is not an extraordinary jurisdiction we are in, or what you call invoking. So in the tribunal, if it is not there, there's a good ground. I tell you, it will take us no time to dismiss this writ petition. We are giving you opportunity because of the fact it's a question of citizenship. You must get an opportunity. It doesn't mean that you can write everything. As the in this writ petition, a statement is made to the effect that the petitioner's parents were not issued any birth certificate at the time of their birth. And there was no such service provided by the state authorities for the period. And accordingly, it is pleaded that the law does not demand the impossible. Stop. This the court query is the effect that whether the plea that the parents applied for the birth certificate is not granted, or that the petitioner applied for a birth certificate of her parents and was not granted. United Counsel for the petitioner pays for his granted time to file. Satisfy the court on that point. In the event no such replies, there is no such record to sustain the proposed reply, we give liberty to the petitioner to have this statement expunged. Next paragraph. Just before you read, Mr. D.K. Agarwala for the petitioner, the respondents are represented. When? When?
Whenever 2 weeks time after vacation.
Okay, please start the application is straightforward.
Item 6.
May I please, Lordship? With an expiry order at page 47.
2017, where is the process service report?
That is not there, Lordship. That has not been obtained. It is reflected in the orders that
Where is that?
page 47, Lordship.
47.
Page 47. This particularly paragraph 3, Lordship. After receiving the reference number such and such for of Foreign Tribunal number 8, Porpeta, issued notice to the proceedee Lalbanu Nessa, wife of Abdul Barik, on 7/3/2016. After receiving the notice on 5/4/2016, it is found that the proceedee does not reside in the above mentioned village. Hence, the reference case is filed to the new address is found. Then paragraph 4, case record put up on 24/5/2017. Till this date, no new address is found. Hence, issue warrant of arrest to the proceedee by this tribunal. In paragraph 5, seen the report of the officer in charge of Sharbuk police station, where he stated that he searched proceedee Lalbanu Nessa, wife of Abdul Barik, village Gugubari, PS Sharbuk, district Borpeta, but not found in the above mentioned address. Hence, he cannot arrest above mentioned at proceedee. Accordingly, Gaubura issued a certificate in the name of Lalbanu Nessa. After
Okay,
going
let us
to the
examine the records. We'll call for the records. Here's
Let the record.
any interim period shall be considered on receipt of the records. Service SD Prokasar and counsel for the petitioner. Also have is S. Barwal and it's CEC appearing for respondent number 1. Mr. J. Payang and Mr. Nicholas for the FT matter representing respondent number 2, 3, and 6. And Mr. P. Sharma and an additional senior government advocate appearing for respondent number 4. And Mr. N. Devi and
On behalf of people.
counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 5. Where is the my copy is at page 47. And the ex parte opinion dated 6/7/2017. Passed by so and so in so and so. Arising out of IMDT reference case number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971. No. Don't see 25/3/71. Foreigner. It to be a foreigner. Notice call for the records. Extra copies within 2 days. The interim prayer made in this requisition shall be considered on receipt of the records of the tribunal. Next paragraph. However, it is provided that that if the petitioner, namely Lal Bhanu Nessa, is apprehended, she shall not be deported out of the country without order of the court. List out votes on receipt of tribunal records.
God bless you.
Item 7.
May please, your lordship. Lordship, in this case, the petitioner declared foreigner.
Just a moment. Just a moment. Heard Mr. F.A. Hassan, learned counsel for the petitioner. As Barwal and CEC appearing for respondent number 1, Mr. J. Pang, Mr. Standing for the FT matters representing respondent number 2, 4,
And 6.
and 6. And Ms. N. Bedi, learned counsel appearing on behalf of Mr. Ms. P. Barwa, standing for respondent number 3, and Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5. Which page is the opinion?
Opinion, my lord, page 91.
Page 91. Opinion dated 23/10/2024. Progress so and so in so and so. Arising out of IMDT case number 3213/97. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copy within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police, border, this place,
Bozali.
Bojali, in 10 days. It will be below 5,000. All those clauses and default clause. 10 days to take the.
Yes, sir. Yes, sir.
Item 8.
My lord, the petitioner, my lord, examined as many as 5 details.
Just a moment. Where is the opinion?
Opinion page, my lord, 117, my lord.
Where is this Jamabandi?
Jamabandi, my lord, page 42. The serial number, my lord, 4. Sultan Ali, he is the petitioner.
Where is the Jamati page number?
42. This is verdict. Yes, 42, my lord, at serial number 4, he is the petitioner, Sultan Ali, son of Muhammad Ali. And my lord,
Which is the entry?
my lord, at page 44, my lord. This is the remarks,
Which one?
page 44.
We are there at 44. Which?
My lord, from top, my lord, third para, Sokro Bikhoira, 28/2018, Tarikor, Namjari, Nong, BARKL/2018.
Mr. Sharma, how could this happen? You know what has happened here? Why we are touching only one document? Come to page 122. DW4 in the middle. You've seen that?
Yes.
You read this loudly.
DW4 deposed that exhibit
No,
F
on
is
being
issued.
questioned.
Lord-
DW on being questioned by tribunal. Third para.
Third para. DW4 on being questioned by the tribunal deposed that there is no mutation order recorded in the name of Sultan Ali in the original Jamabandi book.
So,
Yes, Lordship.
if the original Jamati does not have there, how can a certified copy issued have the entry? The state is doing nothing about it.
Yes, Lordship. In this regard, Lordship may allow the government to take a instruction, Lordship.
No, because it is, you see, we can't direct. We can't issue a direction. We only can take note and inform you. It is for the state to take a call.
Lordship.
We have shown you this. This has happened. Now, it is for your wisdom to take a call. You may want it. You may want him to be as declared to be an Indian. Is it not?
Yes, Lordship.
Then you can only point out. Mr. S. A. Ahmed, Constitutional Petition.
Record.
Ms. S. Barwal, also heard Mrs. S. Barwal, and it says here, pending for respondent number 1. Ms. N. Bedi, and this counsel on behalf of Ms. E. Barwal, standing also for respondent number 2. Mr. G. Sharma, and it's standing also for the FT matters, representing respondent number 3, 4, and 6. And Mr. P. Sharma, and additional senior government advocate for respondent number 5. This is page 117. Opinion dated 31/8/2024, passed by so and so in case number so and so, as you know, to IMDT case number so and so, declaring the petitioner to be a foreigner of post 25/371. Same notice. Extra copies. Call for the records. Petitioner shall appear before the Superintendent of Police, Borpeta, in 10 days and take bail. 10 days time to take bail, my lord. This after 4 weeks on the records.
Obliged.
Item 9.
Lordship, in this case, Lordship, tribunal issues notice to the petitioner is relevant, Lordship, that may be seen, Lordship, page 49. Petitioner born and brought up in West Bengal.
Where is the opinion?
Page 20, Lord.
Page
20.
20. Yes, what do you want to say?
Worship, page 49.
Page
49.
49.
This is a notice, Lordship. Petitioner appeared before the learned tribunal, Lordship, pursuant to that notice, wherein Lordship mentioned Firoza Bibi, wife of Abdul Jalil Sheikh, Lordship.
Abdul Jalil Sheikh.
Sheikh.
Yes.
Accordingly, petitioner appeared with the learner and exhibited some documents like Lordship Kabir Nama, Panchayat certificate, and persons also examined in favor of the petitioner, Lordship, including his elder brother, saying that Lordship he is a daughter of Salam Sheikh. Now, Lordship, kindly see the LBU's report, Lordship, page 68. Page 68, serial number 3, Lordship.
60.
68, Lordship.
58.
68.
68. Okay.
Serial number 3, Lordship.
Yes.
Father, Amazuddin Sheikh, Lordship. Actually, he is my paternal uncle, Lordship. That's why, Lordship, I could not establish my linkage with my father. My father's name was Salam Sheikh, Lordship. He is my paternal uncle, Lordship. And in the voter list of Lordship,
Just a moment.
page 35 may be
which
seen,
is the
Lordship.
notice you are showing us?
Notice 49, please.
Okay. Who is Abdul Jalil?
Husband. Is my husband, Lordship.
Husband.
And Amazuddin, Lordship, whose name was shown to be a father of the petitioner. He is my paternal uncle. That may be seen on page 35. In voter list of 1980, Amazuddin name was shown as a brother of the petitioner, petitioner's father. List recorded in the voter list of 1980, page 35. Though that is a not exhibited document before the learned tribunal, Lordship, we have page 35. 800.
What is the name of your father?
Sheikh Salam. Here mentioned Sheikh Salam. 886.
Where is the finding of the tribunal on that?
On that, Lordship, page 28. In middle portion, Lordship, from top, Lordship, after 8 lines, in the reference, Lordship, right hand side, in the page 28, in the reference, office father name is recorded as Amazuddin Sheikh.
But the tribunal is right. In your written statement, you don't disclose who is
Yes,
this Amir.
that's right, Lordship. We have not pointed out that, Lordship, that she is daughter of.
Okay, let us examine it. Okay, Mr. A.T. Sarkar, Counsel for the petition. Also heard Ms. S. Barwar and CEC evidence for respondent number 1. Mr. G. Sharma and standing counsel for the matters representing respondent number 2, 4, and 6. And Ms. N. Bedi, Leonard, counsel appearing on behalf of P. Barwar, standing counsel for respondent number 3. And Mr. P. Sharma, and additional senior government advocate appearing for respondent number 5. Opinion dated 2/8/2024, page 20. Passed by some influence also. Mr. Sharma, this creates us a lot of confusion when we ultimately when we write orders. Please come to page 20. Many times we have to spend a lot of time in this while correcting the orders. in the top, it is stated before the member foreigners tribunal Roman 2.
Yes.
Down below, he writes present so and so member foreigners tribunal number numerical 2. So which is the correct nomenclature? Because every time when we sign orders, it creates a difficulty.
Yes, Lord, yes.
Which is right?
Roman basically.
Yesterday also something came like this. They wrote Roman 3, and in the seal it is Roman numerical
Yes,
3.
Lord.
Which is the correct nomenclature?
Generally, Lordship, it was written Roman, Lordship, it was written, but
We don't know, I am showing you everywhere it is written. You see, in the first line, Roman 2.
Yes.
For the state, GC Karmakar AGP FT2. So this is what you are writing. If the presiding officer does not know the correct nomenclature of the court he is holding, what can we do? We are small, very small. To know about this, you don't give us a list.
Lordship.
Everywhere he writes.
Lordship,
Either,
just, no, I am
Yeah.
clarifying, Lordship, just now, I am clarifying.
clarify, it's, whether it's Roman 2 or numerical 2. Huh?
Yes, Lord.
Or thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Next paragraph, the learned counsel for the petitioner has submitted that as per the reference, the reference at the report of the LVO, the name of the father of the petitioner was referred as Amezuddin, Amezuddin, Sheikh SK. Mr. Bhava, the petitioner is the daughter of Salam, SALAM, Sheikh, SHEIKH, alias Salam, CHHALAM, Salam Sheikh, SEKH. And it is on that ground that the learned tribunal disbelieved the evidence of the petitioner and she was declared to be a foreigner. Next will be the resignation notice. 4 weeks to extra copies within 2 days. Call for the records. Petition shall be given before the Superintendent of Police border. Which place? Dhubri within 10 days. Bail of rupees 5,000 with default clause. 10 days time to take bail.
Supplementary item 46 for motion.
Made reason. Well, this matter, this PIL is being filed by an investigative journalist. He's a journalist who has worked in all the national papers and he has written a number of books on Northeast. Well, he's concerned with the habitat destruction of the Kaziranga National Park and which has been continuing unhindered for the past 18 years and the non-notification of the eco-sensitive zone. My lord, your lordship, there's a brief background of this case, my lord.
So before that, my learned friend, senior man has to establish that this court is going to admit it or not, because there is an order from this honorable court that this petition will await sine die till the decision, adjourned sine die till the decision is passed by honorable Supreme Court. That was the last order by division.
Yes, my lord.
What circumstances has arisen that warrants taking cognizance of this case?
We have an answer to this. My lord, what has happened, I'll take your lordship to the order of your division bench on 24/10/2024.
Do you have the order of the Supreme Court in the matter?
No, my lord, what has happened? On that day, a submission was made by the learned counsel for the forest stating that this eco-sensitive matter is pending in the Supreme Court. We could get reports from the Supreme Court that on 28th of November, the Supreme Court was taking up two issues. One was the mining in the Karbi Anglong area, And the second was an elevated corridor, which needs the permission of the Supreme Court in terms of a Supreme Court's 2002 judgment. Those two matters were taken up and disposed of. And this order was not there on 24/10/24. So as soon as the Honorable Chief Justice told us that we are going to synodize it, and as and when any matters, orders are passed in the Supreme Court, you make a list. I made a mention before the Honorable Chief Justice showing this order, and he fixed the matter, and that is how the matter has come. Because the objection was taken that since the matter is pending, my lord, eco-sensitive zone is not a subject matter of the Supreme Court. And in fact, if my learned friend insists, I can show an order of the division bench
We do.
on it, this
we-
objection taken by the person, the same
no,
advocate,
we take
4 years back.
We take a simple route. Yeah, on this issue, we put the state to notice and the next week we'll take it up.
Yes, my lord,
Because
what
if-
I propose, my lord, there has been permanent structures in the entire 9 notified animal corridor, and the CAG has given a report that the one-horn rhino, which is a world asset, will be wiped out. Because what has happened, they are getting clogged in the Kaziranga National Park. They need to come out in the suburbs. As a result, because of the massive commercialization and land pattern changes which are happening in the corridors, they can't move. And this has been not looked into by the state government. Central government's minute meetings are there. I have got.
It's okay, but you see, the issue is.
Lordship, notice me.
The issue is very.
Very serious.
No, not that. For the court to take up the matter when there's a statement that it's a matter sub judice before the Supreme Court.
Yes, sir.
Naturally, the state will be represented in the Supreme Court. So
Yes.
we give them a 7 days notice, they will apprise us about
My
the
lord, in fact,
pendency.
that notice is not required.
Yes.
I have filed an affidavit indicating all proceedings before Honorable Supreme Court, my lord.
No. But
We have
whether
not-
this issue of eco-sensitive zone.
Yes.
Is pending before Supreme Court or not,
Where is
on
that?
that, my lord, we have filed an affidavit.
Where is
When?
Yes, my lord, it's there, my lord. My lord, I filed it on 17/9/2024, my lord.
page?
We have not got-
Affidavit, my lord.
we have not got.
Hmm?
What now?
Get about the affidavit.
What is it?
Page, my lord, will kindly take up 542 of the affidavit, my lord. There are so many orders, my lord, that indicates that these issues are being
No.
adjudicated upon by the Honorable Supreme Court, my lord. 542 is an order of the Honorable Supreme Court, and my lord finds at 551, my lord, the relevant part.
561.
542 is the order starts, my lord, and
yes.
551 is the relevant part. my lord.
551.
Yes, my lord.
Yes.
Mr. So-and-so, learned additional advocate general appearing for the state of Assam, submits that the draft notification by issue was approved by the cabinet yesterday. The state of Assam is directed to file an affidavit explaining the steps taken so far. After this court passed the order, dated so-and-so. So Honorable Supreme Court is aware that the process of eco-sensitive zone is going on, my lord. In fact, day before
just a moment.
yesterday, my lord, we have replied to the queries made by the central government.
Just a moment.
Then P026. P0227. P2 will see. No.
Then my lord may kindly peruse the next order at page 555.
Just a moment.
My lord.
Give us 5 minutes.
My lord, sorry.
You have a copy of this order? which
Yes, I
Mr.
have
Das
started a
direct-
copy
Yes,
of the affidavit.
No, this order.
Yes, ma'am, it's part of my affidavit, ma'am. That has already been served to them, ma'am.
I have an
This
answer.
order, no, just a moment. Just a moment, Mr. Das. This order of. What is the date of this order? Mr.
24,
Das?
3, 2000. 24, 3,
this is-
2022, my lord.
2011-24. That is what Mr. Das is now showing us.
Yes, I'm coming. There are other orders, ma'am,
No,
coming
no,
to them.
One by one. I am very slow.
Sorry, ma'am.
As I call myself as simple as a jalebi. As straight as a jalebi. So therefore,
No,
it
certainly
takes
not,
me
ma'am.
some time to reach where I want to go. Correct. Now let me show you something.
Well,
Yes. You come to this page 1 of the order, which Mr. Das has just now given to
Yes.
us.
Page 16.
Correct? Now come to line number.
Which order, my lord? The division bench
Hey,
order?
Mr. Das has given us this
The
order.
division bench order, yes, ma'am.
No, not division bench.
Supreme Court order.
Yes, ma'am.
Latest.
Yes.
Correct. First page.
Yes, ma'am.
Line number 9 from top.
Yes, ma'am.
Yes. IA numbers
28905.
28905.
Yes.
It is here.
Yes.
Now 28905.
Yes, ma'am. This
in
is the order.
Order. You will find this come to first page of the order,
My lord.
page 16. Yes. That is the first page of the order.
My lord. Yes,
Serial number 2.
my lord.
IA number so and so. Third line is 28905.
My lord.
28905 is disposed of.
Disposed of.
Absolutely.
28905, my lord, deals with what, my lord? 28905 deals with, my lord, illegal mining in Kaziranga. There is an order of the Honorable Supreme Court I have annexed that all mining should be banned. Then that IA was filed seeking some.
No. Just now you said, when we started, you said that the issue of
Yes.
eco-sensitive zone
Yes.
is covered by 28.
No. Issue of eco-sensitive zone is covered by the main writ petition. There are so many hundreds of IS filed. That order came to be passed in the IA.
No, you see, for the purpose of this court not taking up a matter,
My lord.
you have to demonstrate that this is the clear in the Supreme Court and therefore
Yes.
it is
Yes,
what you call, barred under the principles of
Yes.
the issue estoppel.
Yes.
And we should not take it up.
Yes, madam.
So therefore, only you have to demonstrate that this is the pleading before the Supreme Court. This is the writ petition number or an IA number.
Yes, ma'am.
And this issue is sub judice.
Yes,
This
then
is
I
not a-
can show from my affidavit itself. All the
Show it-
materials are there.
show it, this is-
Before that, my lord, peruse this order, my lord.
Huh.
The orders served by the other side, my lord. Finally, my lord will see what was the order, my lord. Paragraph 5, my lord.
Yes.
Paragraph 5 at page 17.
Yes.
In the affidavit filed on behalf of the KAAC, dated so and so.
Just before that, we'll tell you one thing. I've not gone through it because it's too bulky to read it yesterday when I got the brief. You see, I'm taking cue from a fact that whenever there is a notified forest,
My lord.
there must be a zone created.
Yes,
Absolutely.
Where there can be some activity,
Yes.
where there cannot be an
Yes.
activity.
Yes, ma'am.
And this issue came up when I was taking up bench.
My lord,
bench
There is an order
four.
of your lordship. I
Ah.
am holding that, my lord,
Ah.
wherein, my lord, some of the miners came and filed writ petition seeking leave to leave their stones. My lord passed an order that go to Supreme Court. We cannot pass anything here, my lord. That is
Yes.
what precisely I am
Because-
submitting, my lord.
Because the eco-sensitive zone must be
Yes, that
notified.
is what precisely we are submitting.
Otherwise,
There are, my lord, orders to indicate. There are 2-3 orders to indicate that one central import committee was created. Honorable Supreme Court has specifically directed that anybody aggrieved has to go to central import committee or else come to us. That means Honorable Supreme Court.
Sure.
Yes, ma'am. But this order, my lord, deals with paragraph 5, my lord, can you see?
I'm there at paragraph 5.
In the affidavit filed on behalf of KAC dated so and so, it is stated that all the mining activities inside Karbi Anglong district bordering the southern part of
Where-
Kaziranga
where-
National Park,
You are reading where?
paragraph 5, my lord, of that order at page 17.
This order.
This order, my lord. That my learned senior, my lord, just now.
Okay. There at page 24 also there is an order of serial number 5. I was there. Okay. In the affidavit, page 17. Yes.
Not affidavit, my lord, the order dated, my lord,
Yes. In the affidavit,
2011, 2025.
in the affidavit filed by on behalf of KAC.
Yes, my lord.
Yes.
dated so and so, it is stated that all the mining activities inside the Karbi Anglong district bordering the southern parts of Kaziranga National Park has already been closed pursuant to the meeting of the CEC, Central Empowered Committee, madam. It is further stated in the affidavit that notice to close 33 stone quarries and 18 numbers of stone quarries as well as 18 stone crushing units was issued. It is further stated in the affidavit that mining activities along the southern boundary and catchment area of the river stream originating in Karbi Anglong Hills has already been prohibited by order dated so and so, passed by the Deputy Commissioner Karbi Anglong. The affidavit also places on record a letter dated 7/5/2024 issued by the Divisional Forest Officer KAHC stating that no new order for lifting of closure of quarries has been issued. We therefore find that the KAC has also taken necessary steps to stop the illegal mining and the areas bordering KNP. We therefore close the proceedings in so far these two issues are concerned. Issues regarding, my lord, pertaining to that Karbi Anglong side, my lord, that has been closed because Honorable Supreme Court is satisfied that government is taking up steps. That is gone, my lord. So this disposal of this IA, my lord, has no connection whatsoever with the adjudication of the main issue of eco-sensitive zone. For that, my lord, I would like to take your lordship to my affidavit again, my lord. That it is true, my lord, that the earlier order that I have placed, it was passed in that IA. But the issue of eco-sensitive zone and all other consequential things are the main subject matter of the proceeding before Honorable Supreme Court.
We are not acquainted with that.
My lord will kindly peruse, my lord, my affidavit page 555, my lord. Merely because this order has been passed, that doesn't mean, my lord, the eco-sensitive zone issue has been, my lord, decided by Honorable Supreme Court. It is still pending. So the change from the last date when my learned senior also, my lord, admitted before the court, he fairly submitted that the issues are pending in the Supreme Court. So what has changed? This IA has been disposed of. What has changed, my lord? What has changed, my lord? This IA has been disposed of that deals with Kaziranga, Karbi Anglong side, my lord. Page. Spreaded sleeve. Notice upon dealer next day. Assam Tribunal in adjourn mein front page of news. अपना client है, protein और page legal social media दिसे. So it's a publicity interest दिखेगा अभी हम. Petition का information disseminate होती है. Exactly. जाने के लिए site है. ये तो मुझे जाने. हाँ. He would take main paper from a test. No, Babu, to me, need to better. My lord knows, my lord, this case, original case is TN Godagoram case, my lord. There are so many orders passed in this proceeding. So the original case was of something else, my lord. It had spreaded its limb. Honorable Supreme Court has taken cognizance of different issues in this proceeding. So we cannot relate to the prayer of the original writ petition because it has nothing to do with Kaziranga eco-sensitive zone. But there are orders to indicate that these are issues substantially before Honorable Supreme Court. Page 555.
That is why, incidentally, we have an example of sea life, which is octopus.
Yes.
You cut off a part of his arm,
Yes.
it grows back.
Tentacles.
It goes back and
So at this stage, my lord, cutting an arm of the Honorable Supreme Court, my lord, may not be justified. my lord.
No, we don't know. We are not saying about cutting of arms. But you see, we are referring to this Godavarman.
Yes, that is the
So
current
many
case.
things are happening that the tentacles has to spread.
Yes, my lord. We
Otherwise-
welcome that, my lord. State has always welcomed that.
It's a subject matter of Harvard and American, Australian universities. They are proud that the Supreme Court is
Yes,
going for
state has
forest
always
governance.
welcomed, my lord. State has always
Malad,
welcomed.
I have a
Page
submission.
555, my
No,
lord.
just
All
let-
of this
let him
submission-
complete.
Let me complete.
No, no, let the additional advocacy will complete.
Page 555, my lord, of my affidavit annexer D. My lord will see there are so many IAs referred to, my lord.
Yes, yes.
Then finally, next page 555, in the matter of WPC number 202 of 1995. This is the famous Godabaram case, man. That is where orders are being passed. Then if my lord turns to page 558, my lord. At the top of the page, my lord, first line,
Page number 55?
558, my lord.
8.
Yes.
558, yes.
What are the issues that has been also recorded here, my lord? In this first top of the line, my lord. First line, my lord. In this, the sentence starting with the word in this.
Yes.
In this order, we shall be mainly dealing with two sets of issues. The first set relates to mining activities in and around a wildlife sanctuary in the state of Rajasthan, known as Jamuna Ramgarh, also spelled as Jamua Ramgarh. The second set of issue is wider in scope and involves prescribing eco-sensitive zones surrounding the wildlife sanctuaries and national parks. The subject of mining and other commercial activities within the wildlife sanctuaries and national parks protected and shall also be dealt with by us in this order. So, my lord, eco-sensitive zone is very much a substantial issue before the Honorable Supreme Court. If now, my lord, peruses page 607. Paragraph 44, it starts, my lord. Some prescriptions were given by the Honorable Supreme Court. What should be the minimum distance criteria? Initially, it was held to be minimum 1 kilometer. Now there are orders which says it can be reduced from 1 kilometer, my lord. If my lord turns to that same paragraph 44 at subpara, my lord, P 614. 614 of the affidavit, my lord.
No, this 1 kilometer
Yes.
is specific to Jamuna Ramgarh.
No, my lord, 1 kilometer was for all. This was for all, my lord. We accordingly direct. Each protected forest, paragraph 44, my lord, there is national park or wildlife sanctuary must have an eco-sensitive zone of minimum 1 kilometer measured from demarcated boundary of such protected forest in which the activities prescribed and prescribed in the guidelines of so and so shall be strictly adhered to. For Jamna Wildlife Sanctuary, it shall be 50 meters, 500 meters. For Jamna, it was reduced. For the rest of the country, my lord, it was 1 kilometer. There are so many orders, directions in this paragraph regarding eco-sensitive zone, all around eco-sensitive zone. Then, my lord, may kindly turn to, for example, my lord, page 610, paragraph F. The minimum width of the eco-sensitive zone may be diluted in overwhelming public interest, but for that purpose, state or the union territory concerned shall approach the CEC and MOEFCC, and both these bodies shall give their respective opinion recommending before the court. Then, my lord, paragraph G, in the event the CEC, MOEFCO, and Standing Committee of National Board of Wildlife or any other body of persons or individual having special interest in environmental issues consider it necessary for maintaining a wider or larger ECZ in respect of any national park or wildlife sanctuary, such body or individual shall approach the CEC. In such a situation, the CEC shall be at liberty to examine the need of a wider ECZ in respect of any national park or wildlife sanctuary in consultation with the stakeholders, including the state or the union territory concerned, MOEFCC, as also the Standing Committee of National Board of Wildlife, and then approach this court for its recommendations. So then again also, my lord, thereafter Honorable Apex Court is to be approached. Then, my lord, next paragraph is very relevant. Oh, sorry, that's not relevant. So I would like to take your lordship to paragraph P, my lord. These are all directions on the eco-sensitive zone, which was subsequently, my lord, again amended by the Honorable Supreme Court, modified by the Honorable Supreme Court. Page 614, paragraph P, my lord. 614.
Yes.
Paragraph P. In the event there is any subsisting order of any high court or any court subordinate to such high court covering any of the issues dealt with by this court in this order shall prevail over any such order which may be contrary to these directions. Then, my lord, this order, my lord, came to be reconsidered by the Honorable Apex Court. Paragraph 46 was modified, 44 was modified, and this order, my lord, speaks of a order dated 3/6, same order, my lord, page 616, my lord, may kindly turn. 616. This is order dated 26/4/2023. 26/4/2023 by the Honorable Apex Court. There are so many orders passed, my lord. Some confusions are there. I have already placed before your lordship paragraph 44, my lord, wherein 1 kilometer was fixed initially, and for Jamua Ramgarh, my lord, it was 500 meters. That order has been quoted. Here it is reflected as 56.1. In that order, my lord, it was 44.8.
This page 616 is order dated?
Order dated, my lord, 26/4/2023.
Twenty
6/4/2023. 26th of April 2023.
Yes.
That, my lord, may kindly turn to page 617. That order has been quoted. It's protected paragraph, sorry, page 617, paragraph 2. The applicant specifically seeks modification of the directions contained in paragraphs 56.1 and 56.5 of the order dated 3/6/2022. The said paragraphs are reproduced below. Number 1, I will read only, my lord. Each protected forest, that is National Park or Wildlife Sanctuary, must have an ESZ of minimum 1 kilometer measured from the demarcated boundary of such protected forest in which the activity is prescribed, and the prescribed in the guidelines of 9/2011 shall be strictly adhered to. For Jamua Ramgarh Wildlife Sanctuary, it shall be 500 meters so far as subsisting activities are concerned. So, my lord, that for para 44 has been quoted here as 56.1. Then, my lord, I will take your lordship to paragraph 48, my lord.
This is same para 44. 56.1 is para 44.
Para 44. Because of the IAs, my lord, hundreds of IAs filed in the Honorable Supreme Court, my lord, there are some confusion in reading these orders, my lord. Paragraph 48, my lord, may kindly turn, my lord. That, my lord, finds it.
No, just now.
My lord.
After page 617, which page?
It is 656, my lord. Same order, my lord. My humble submission would be, my lord, anybody being aggrieved, my lord, only because the petitioner resides at Guwahati, will file a writ petition in the Honorable Court while the issue is pending before Honorable Supreme Court. There are issues before the Honorable Green Tribunal also, my lord.
No, but this affects
Well,
the entire.
I can understand the
populace.
anxiety of the petitioner, my lord, but there are so many issues to be taken note of, my lord, while declaring this eco-sensitive zone. Only because emotionally the petitioner is affected, my lord. Better.
No, not emotionally. This is something which is a stark reality.
Exactly. So, para 44 will, my lord, how the Honorable Supreme Court also appreciates, my lord, the diversity of the issues, my lord. Paragraph 48, my lord. If the direction as issued by this court in paragraph 56.5 of the order dated 3/6/2022 supra is continued, then no permanent structure would be permitted to come up for whatsoever purpose in the aforesaid ESZs. As already pointed out from the aforesaid examples, hundreds of villages are situated within the ESZ in the country. If no permanent construction is to be permitted for any purpose, a villager who is desirous to construct his house would not be permitted. Similarly, if there is an extension of their family and some additional construction is required for accommodating the enlarged family, the same would also not be permitted. Similarly, if the government decides to construct schools, dispensaries, anganwadis, village stores, water tanks, and other basic structures for improvement of the life of the villagers, the same would also not be permitted. The effect of the order will be to prevent the state or the central government from constructing roads and provide other facilities to the villagers. 49, my lord. If the order dated 3/6/2022 Supra is not modified, it will also be impossible for the Forest Department to conduct eco-development activities around national parks and sanctuaries. The said activities are required with the dual object of protection of wildlife and provision of the benefits of the local communities. MOEF and CC provides financial assistance to the states under the centrally sponsored scheme Integrated Development of Wildlife Habitats, which includes assistance for eco-development activities. These activities often involve construction of small structures which are permanent in nature in areas including ESZ. For example, the said activities which are likely to be prohibited are thus: the construction of community halls, bridges, threshing floors, drying platforms, drinking water storage, etc. for the benefit of local communities, villages. The construction of forest chokis, watchtowers, and other structures for protection of wildlife and forests. The construction of interpretation centers, toilets, and other basic structures for the environment, education, and the visitors of national parks and sanctuaries. It is further to noted that there are various regulated and permissible activities. There are also certain projects of national and strategic importance, such as construction of national highways, railways, defense-related infrastructure, etc. The effect of direction in 56.5 of the order dated 3rd June 2022 Supra is that all such activities will be permanently prohibited. In this respect, it is to be noted that MOEF and CC has issued an office memorandum dated 17 May 2022, which requires that any activity listed in schedule of the EIA notification 2006, when conducted in a notified ESZ, or in the case of national parks or sanctuaries for which no ESZ has been finally notified, when conducted within 10 kilometers of such national park or sanctuary, requires the consideration and recommendation of the NBWL or its standing committee in addition to the Environment Clearance under 1986 Act. Additionally, activities which are regulated as per the specific ESZ notification require approval as per that notification. As such, we find that there are inbuilt safeguards for preventing rampant construction and abuse of process which may be detrimental to the development and maintenance of wildlife habitats. It is further noted that if the direction as contained in paragraph 56.5 of the order dated 3/6/2022 Supra, that even for continuation of existing activities, the permission of PCCF of each state and union territory would be necessary, remains unmodified, taking into consideration that each state and union territory, there will be hundreds of villages wherein millions of people would be residing. The PCCF would be left with no other job except to consider such applications for permission. Even a farmer desirous to continue farming activities would be required to seek permission. We find that such a direction is impossible to be implemented. We are of the view that if such a direction is continued, rather than avoiding man-animal conflict, it will intensify the same. As observed in the said guidelines, the requirement of declaring ESZ is not to hamper day-to-day activities of the citizens, but is meant to protect the precious forest and protected areas from any negative impact and to refine the environment around the protected areas. As already discussed here above, the necessity to have ESZ is to provide a buffer zone around the protected areas. The rights of the villages residing in the protected areas are required to be settled in accordance with the provisions contained in the 1972 Act, and such villages are rehabilitated outside the protected areas. However, no such settlement of rights is available to villagers residing in ESZ. Wildlife sanctuary, if somebody is residing, well, he is entitled for some benefit. Land Acquisition Act will be applicable. But for the eco-sensitive zone, my lord, there is no protection to them, my lord. That's why Honorable Supreme Court has rights, my lord. However, no such settlement of right is available to the villagers residing in the ESZ area. As stated in the said guidelines, the purpose of declaring ESZ is not to hamper the day-to-day activity of the citizens. If the direction as issued is continued, it would certainly hamper the day-to-day activity of the citizen residing in ESZ. As such, we find that the direction needs to be modified. Then, my lord, it is next paragraph. It is further to be noted that NBWL in its meeting that so-and-so has also recommended that the de-alienation of ESZ should project as regulation rather than prohibit of actions. My lord, I would like to take your lordship to, there are so many, paragraph 55 is very relevant, man. Insofar as direction in paragraph 56.1 of the order dated 3/6/2022 Supra is concerned, a perusal of various orders would reveal that this code has not directed any minimum area from the demarcated boundary of such protected area. The area to be declared at ESJ cannot be uniform and will be protected area specific. In some cases, it may be 10 kilometers on one side and 500 meters on the other side. In certain cases, it may not be possible to have a uniform minimum area by virtue of interstate boundaries or a sea or a river beyond one side of the protected area. In any case, a detailed procedure is required to be followed as prescribed under Rule 5 of 1986 rules, which we have already referred here above. We find that once such a notification issued after following the procedure prescribed under the 1986 rules, the ESJ will have to be as per the said notification.
So the Supreme Court has now again in this page,
Order.
paragraph 55
Yes.
has clarified that we find that once such a notification.
Yes.
is issued-
Once notified, my lord,
No, this notification will be issued by whom?
central government will. Central government will issue the notification. We'll send the draft
Proposal.
We'll send the proposal for ESJ. That will be placed before so many committees, then central government will do it.
Okay.
Presently, my lord, our situation is that we are meeting up the queries of the central government. In fact, day before yesterday, again, we have submitted certain queries, my lord, answer to their queries, my lord. It's an ongoing process. It will be done. My anxiety is that, my lord, once the repetition is allowed here, any order passed, my lord, the Honorable Supreme Court, my lord, has seen from time to time orders are being modified. It is solely under the monitoring of the Honorable Supreme Court. So there may be, my lord, divergence of orders, my lord. So that's why it was submitted before the division bench by the petitioner side also, that let us await outcome of the proceedings. The division bench in the earlier order has said that adjourn sine die, but it can be listed subject to orders passed by the Supreme Court, final order or interim orders. The order that now they are placing on record, my lord, is that in respect of Karbi Anglong, things are good. So the Honorable Supreme Court has closed it. But ECZ has not been closed, my lord. ESZ. If my lord perishes paragraph 57, my lord. Paragraph 57, my lord. It is pertinent to note that after following the aforesaid procedure, the matter is placed before the expert committee consisting of 13 organizations having expertise in the relative field. As such, before an
In
ECS,
this paragraph, it says.
paragraph 57, my lord.
No, paragraph 56.
My lord.
It says that it is required to be published in the official gazette in such manner.
Yes, my lord.
Central government deemed necessary.
Yes.
Time to any person interested in filing objection.
Yes.
Now, this draft notification, has it come out for the state of Assam?
No, my lord. Draft notification has been prepared. It is not yet published. For the objection part, my lord, we are yet to publish because we are meeting the queries of the central government. Once it is done, my lord, draft notification will be notified. All my claims and my lord will be entertained. Then final notification will be issued. Paragraph 57, my lord, may peruse. It is pertinent to note that after following the aforesaid procedure, the matter is placed before the expert committee consisting of 13 organizations having expertise in the relative field. As such, before an ESJ area is specified, various factors are taken into consideration. There are various factors which will determine ESZ for a particular protected area. The circumstances may differ from one protected area to another protected area. As such, we find that the directions which prescribe a uniform 1 kilometer ESZ requires to be modified. So, my lord, it's an ongoing process, my lord. Honorable Supreme Court also my lord, Honorable Supreme Court has never directed that to the state of Assam to notify it within the time frame, because it is not such a simple thing, my lord. That is why paragraph 58, my lord. Despite taking note of this, my lord, there is no specific direction granting, giving a time to notify it. Paragraph 58 says, my lord, it is further to be noted that on the date of filing of the present application, final notifications have been issued in respect of 474 protected areas, whereas draft notification have been issued in respect of 101 protected areas, and 73 proposals are pending. So there are pending proposals like ours, my lord. But there is no direction by the Supreme Court that do it within 30 days, within 60 days, because it is not possible, my lord. As already discussed herein above, this court has already found the said guidelines to be reasonable and has accepted the same. The court has also accepted the view of the standing committee so and so. My lord, I will just skip only two paragraphs, my lord. Paragraph 61 and 63, my lord. Paragraph 61, my lord. We are therefore inclined to allow the present IA at page 664. The direction in paragraph 56.1 of the order dated 3rd June 2022, Supra, is modified and clarified that the directions contained therein would not be applicable to ESZ, in respect of which a draft or final notification has been issued by the MOEF CC, and in respect of the proposals which have been received by the ministry. 63 is relevant, my lord. It is further directed that any person who is aggrieved with such a final notification would be entitled to approach this court directly by filing an application in the present proceedings. So issue before the Honorable Supreme Court, there are so many issues in the Godavarman case, but issue of eco-sensitive zone is essentially a prime issue before the Honorable Supreme Court, my lord. So at this stage, entering this and taking cognizance of this repetition, my lord, may lead to confusion, my lord. If my lord peruses the first order, my lord, page 527. Page 527. From here, my lord, the ECZ issue start. And when we depose before the Honorable Supreme Court that we are doing it, Supreme Court has directed us to file affidavit. Maybe in a IA that has been disposed of, but it is very much an issue in the main case also. Page 527, my lord, may kindly pay attention. That is an order, my lord, of as old as of my lord 9/5/2002.
Which one? Which page?
Page 527 of my affidavit, my lord.
527.
Yes, my lord, you kindly see the date 9/5/2002. Same case, my lord,
9/5/2002.
TN Godapuram, WPC 202,
Yes.
1995.
9/5/2002. Yes.
Yes, my lord. Then my lord may kindly turn to page 531. After hearing the learned amicus curiae, counsel for the parties and taking into consideration the suggestions placed before us by the learned Attorney General, we pass the following orders. Final position. Number one, it is submitted that till the central government constitute a statutory agency as contemplated by Section 3 of the Environment Protection Act, Environment Protection Act 1986, it is necessary and expedient that an authority be constituted at the national level to be called Central Empowered Committee, hereinafter referred, the Empowered Committee for monitoring the implementation of Honorable Court's orders and to place the non-compliance of cases before it, including in respect of encroachment removals, implementation of working plans, compensatory afforestation, plantation, and other conservation issues. Paragraph 4, my lord, any individual having any grievance against any steps taken by the government or any other authority in purported compliance of the orders passed by this Honorable Court will be at liberty to move the committee for seeking suitable relief. The committee may dispose of such application in conformity with the orders passed by Honorable Court. Any application which cannot be appropriately disposed of by the committee may be referred by it to this Honorable Court. So, well, anybody aggrieved, if the petitioner is aggrieved by non-issuance of eco-sensitive zone, animal corridors, they can file an application before the Chief Central Empowered Committee. That committee has attained finality recently and notification has been passed. This is the committee under act now. So they can make an application before the committee, highlight their grievances, make a representation. If nothing happens, they can go to Honorable Supreme.
What is that committee?
Committee final notification. It should be here, madam.
We'll take a short break and come back.
My lord, my lord.
Take a break and come back.
My lord. I was submitting, my lord, this order at page 531, my lord, that CEC was constituted. Any person aggrieved has to go to CEC. If that cannot be decided, then has to approach the Honorable Supreme Court. That CEC, my lord, finally, my lord, though it was an ad hoc body initially, it has become a permanent body. There is an order of the Honorable Supreme Court, pursuant to which 18/3/2023 order, my lord. I will see at the top of the page, WPC number 20295, same TN Godapuram case, my lord. Order dated 18/8/2023. Then second paragraph, my lord. On 18/5/2023, this court passed the following order. On the last date when the matter was heard, a suggestion was made by the bench that instead of the Central Empowered Committee being an ad hoc body, it would be in the larger interest that the CEC as an institution should be a permanent statutory body. Mr. So-and-so, Learned Solicitor General, has accepted the said suggestion. He states that the Union of India would publish a draft notification under the provisions of the section of the Environment Protection Act 1986, providing for the constitution of the CEC. This was quoted, my lord, the last order. Then, my lord, if we skip that, my lord, at paragraph 5, my lord. We therefore permit the Union of India to proceed further with the issuance of the notification for constitution of the Central Import Committee as a permanent body. We find that rather than CEC functioning as an ad hoc body, its functioning as a permanent body would be in the interests of all the stakeholders. We permit the MOEFCC to proceed further with the constitution of the CEC in accordance with the notification that will be issued by the MOEF. That was issued on 23/9/2023. That notification, I am not holding it right now. The date is 23/9/2023. That has been notified. So, my lord, the petitioner has either have to approach the Honorable Supreme Court, or they can also go to the Central Import Committee. Then, if we, my lord, see the last order of this Honorable Court in the present proceeding, 24/10/2024. Third paragraph, my lord. Order dated 24/10/2024, third paragraph, the sentence starting with the line, the learned counsel appearing for the state. The learned counsel appearing for the state has raised a preliminary objection that the matter regarding declaration of eco-sensitive zone in respect of Kaziranga National Park is pending consideration before Honorable Supreme Court. And from time to time, the Honorable Supreme Court has passed various orders issuing certain directions to the state of Assam as well as the other states. The learned counsel has therefore submitted that as the matter is already pending for consideration before Honorable Supreme Court, this writ petition be kept pending for consideration till any final order is passed by Honorable Supreme Court in the above referred case. The learned counsel for the petitioner has frankly submitted that since the matter regarding declaration of eco-sensitive zone in respect of the Kaziranga National Park is pending consideration before Honorable Supreme Court, the matter may be kept pending till any final or effective order is passed by Honorable Supreme Court on that issue. In view of the above, submissions made by the learned counsel appearing for the parties were of the view that this PL be adjourned sine die, awaiting the decision effective orders passed by Honorable Supreme Court in respect of declaration of eco-sensitive zone in Kaziranga National Park. After the decision, effective order passed by Honorable Supreme Court in so and so, the parties are free to move application for listing of this PL petition. So, my lord, according to the petitioner, now the effective order is, my lord, order recently passed by Honorable Supreme Court on 20/11/2024. That they have already submitted before your lordship. So it was their own admission before Honorable Division Bench. The ESZ is substantially an issue before Honorable Supreme Court. In fact, my lord, if we see the prayers are to, my lord, implement the Honorable Supreme Court's order. For that, there is Central Import Committee. If we see the prayer of the PIL, my lord, page 82, my lord. First prayer, my lord. A writ in the nature of mandamus to the state of Assam to notify eco-sensitive zone, page 82, my lord, PL, of the Kaziranga National Park in terms of the Honorable Apex Court direction passed in WPC number so and so, so and so. So that they are not submitting something new, my lord. They say there are certain orders of the Honorable Supreme Court that are to be implemented through this Honorable Court, my lord. For that, my lord, appropriate court would be the Honorable Supreme Court, my lord. If we have failed to comply with the orders, my lord, they can definitely highlight before Honorable Supreme Court. That's why I was submitting, my lord, only merely because the petitioner resides at Guwahati. This cause of action, which is sub judice before Honorable Supreme Court. Even the next prayer also, my lord, protect the biodiversity and ecosystem of Kaziranga National Park, including eco-fragile zone, and restitute the environment, ecology, and biology, so and so, so and so, by strictly adhering to the directions of the Honorable Supreme Court passed in so and so, so in WPC 202. Their prayers have arisen out of the proceedings of the Honorable Supreme Court, my lord, which are still pending. We are interacting with the central government towards notification of the ESZ, my lord. Last one, 18 years. In fact, if I may place before your lordship, my lord, on day before yesterday, my lord, we have again made certain queries by the central government, my lord. So we have written reply to the additional Director General of Forest Wildlife.
We take your word for it because we don't want to burden it
Yes.
without being an affidavit.
Yes,
Take
my
your word
lord.
for it.
Okay. Then, my lord, if we see, my lord, the order of the Honorable Supreme Court, last order 2011-2024, wherein the Honorable Supreme Court was satisfied with the developments of the Karbi Anglong side of the Kaziranga National Park regarding mining and this elevated corridor part. That's why that IA has been disposed of. While that case was pending, while that IA was pending regarding mining, a gentleman, my lord, preferred approach this Honorable Court.
You see, there is also a issue, a very tricky issue in this Karbi Anglong.
My lord.
Although you say that this matter was disposed of, this I have not come across any document where the stock of the mine products is stated to be nil.
Yes.
So therefore, what is happening?
They're filing applications and taking it out.
They are saying that it's a mine product which is available at site and therefore
We have to lift it.
to lift it.
Precisely, my lord. On that, my lord had already passed an order, my lord.
No,
That is
understand
your
that.
lordship's order, my lord.
No, we know that. You see, that is an issue because very strange submissions were made at one point of time.
Yes, my lord. This type of
And
mischief,
therefore-
my lord, people will definitely resort to, and we should be vigilant enough, my lord. Definitely, my lord. There will be attempts, my lord.
More than 15-20 metric tons of mine materials are washed away.
Exactly. Exactly. my lord.
Meghalaya also a serious thing. The
Meghalaya, we
Justice
can't say about it,
Pothoki's report, he's saying that the mine should be sealed now.
No, now it has been allowed. There's Coal India. Now it has been done through Coal India.
It's not that, but
If my lord,
once you are once the state is sensitive about these issues, and these issues can be plugged, then real implementation of the Supreme Court order is there. Otherwise,
Absolutely.
there are many ways to take it out.
but there is always there are two things. My personal experience with these forest cases, my lord, there is always a conflict between, my lord, need of development and ecology. So a balance has to be maintained. If we want to develop more, we have to, because for example, my lord, fossil fuels in Northeast can be found only inside a forest, like petroleum products, my lord. So if we explore there, some amount of damages will be caused. So making a balance of these two interests, ecological balance and the need of development, that is very tricky, my lord. And clubbed with the fact, my lord, there are several corrupt officers, my lord. Coal mining, my lord, we are trying our best, my lord.
Not on that, you see, because you see, let us say give a very simple example. It is permitted to have residents in the very core place because of the fact that traditionally the forest dwellers are staying there. Now, what happens if a brilliant person thinks that he would need the family would grow, and naturally he will need a 20-room house. And then since the family does not grow, he says that to maintain the house, I am now keeping what you call paying guests.
Yes.
He doesn't start a resort.
Yes.
He does all these things.
There has to be a village development committee. That committee can do this type of ecotourism, my lord, in these protected areas. But there are resorts coming up.
So that is why it is easier for the local activist to be in the local court. So they can highlight it immediately.
True, madam. That type of issues, madam, will definitely seriously, will also not object to it, madam. But it is an issue of, madam, notification of eco-sensitive zone. If my lord peruses this order of your lordship, this Moyur Stone Crusher, that WPC 7717, 7717. What I am basically contending, my lord, there were several issues, including eco-sensitive zone and illegal mining in Kaziranga. When illegal mining in Kaziranga was pending, this was the order your lordship had passed, my lord. Paragraph 2. The petitioner herein is aggrieved by the order dated so-and-so passed by the divisional forest officer, whereby the petitioner's stone crusher unit along with other stone crusher units have been restrained from carrying out their activities in view of an order dated 12/4/2019 passed by the Supreme Court in the case of in RET and Godavarman versus so-and-so, and more particularly in respect of an order in IN number 4299 of so-and-so. Then, my lord, we objected. paragraph 5, my lord. Paragraph 5, my lord, pass this order, my lord. This court, upon hearing the learned counsel for the parties, is of the opinion that words used in the order of the Honorable Supreme Court dated 12/4/2009 mentions about mining and related activities. It is also seen that the said proceedings are presently pending before the Supreme Court. And in the opinion of this court, it would not be proper for giving an interpretation to the term used in the order, that too when the said proceedings are presently pending before the Supreme Court. Under such circumstances, this court, while not interfering with the order dated 30/4/2019, as has been assailed in the instant proceedings, observed that the petitioner would be at liberty to approach the Honorable Supreme Court to seek clarification as to whether the stone crusher unit would come within the ambit of the ward-related activities as mentioned in the order that so-and-so. Taking into account the order which has been passed hereinabove, so-and-so submitted that the petitioner may be permitted to take out the already finished so-and-so which are lying in so-and-so. So, my lord, while the issue of, my lord, mining in Karbi Anglong side was pending, my lord observed that the petitioner rather should approach the Honorable Supreme Court. Similarly, my lord, now the issue of eco-sensitive zone is pending before Honorable Supreme Court. Ideal course of action would be, my lord, to approach the Central Empowered Committee, and if agreed, my lord, they can go to the Honorable Supreme Court, or directly they can go to the Honorable Supreme Court. There are orders that I have already placed before your lordship, that anybody aggrieved can go to the Supreme Court. That is why, my lord, precisely because of this reason, my lord, the earlier order was passed, wherein, my lord, it was decided to adjourn the case sine die and await outcome of the Honorable Supreme Court's order. Honorable Supreme Court recently passed this order that has now no connection whatsoever with the eco-sensitive zone. The IA that has been disposed of pertains to mining in Kaziranga. And if I may be allowed to be little technical, my lord, they have not filed any representation, no representation before the Central Empowered Committee. Under that circumstances, my lord, whether a PIL is maintainable or not. In my humble submission, it is not maintainable. Our High Court's rule says, PIL rule says, they have to make a statement at paragraph 6 regarding the details of representations and how it has been reacted by the authorities. That they have not done. There is a division bench judgment, my lord, of this Honorable Court that paragraph has been held to be mandatory, in the absence of which, my lord, PIL is liable to be dismissed. So my humble submission will be, my lord, in the present form, my lord, either the PIL is to be dismissed or we can wait for some effective order on the eco-sensitive zone and animal corridors whatsoever, my lord, of the Honorable Supreme Court, or else there will be multiplicity of proceedings leading to, my lord, confusion, even to the implementing agencies also, my lord.
Yes, Mr. Asif. Well, from the submission of my learned friend, basically they have taken two objections. The first objection is regarding whether this court can take up any matter when a similar matter is pending in the Supreme Court. Well, his answer is being, his question is being answered by this division bench in a similar matter where the same counsel had appeared in the Dibru Saifa drilling case. There, the division bench of this court stayed the entire operation because without biodiversity test, operations were being done. And the objection was taken, same objection which has been taken today. Your Lordship will come to page 4 down below. It has been submitted by the learned senior standing counsel. There all appeared. That is a subject matter which the Honorable Supreme Court as well as the NGT are considering, which, however, has been denied by the learned counsel for the petition. Well, I appeared for the petitioner. Accordingly, it is made clear that this interim order passed in the proceeding today will be subject to any orders that may be passed by the Supreme Court or NGT as the case may be. So, my lord, there is absolutely no bar in your lordship issuing notice on this matter for the simple reason that my learned friend is harping on the Central Empowerment Committee's power. And we are not disputing Central Empowerment Committee's power, but that power will come only if the state government has issued notifications under the central government's direction of OM of 2011 regarding eco-sensitive zone. For 18 years, the Assam government was keeping the matter, was dragging its feet to the extent, if I may be given a chance to read certain documents. Lordship, I can fortify my case. Your Lordship will first take the CAG report. I won't take your Lordship to the voluminous document at page 364. This is an audit done on Kaziranga by an independent agency, the Central Auditor and Controller and Auditor General. The CAG reports basically starts at 285. And I won't trouble your lordship. I'll take certain portions of the CAG report. 364. 364. Well, the seriousness of this case can be gauged. From the result of the physical, it is 14.2.11. From the result of the physical verifications, interaction with wildlife authorities, villagers, and scrutiny of various correspondence, it would appear that uncontrolled and even increasing construction, human settlement, with urbanization at places, commercial activities, mining had contributed to blocking majority of the stretch of NH 37, including the designated animal corridors. Our case is on the 9 functional corridors, except some patches of Haldibari and Burapahar, non-declaration of EHJAD. Well, this is an issue. For such a long time had a direct bearing on such activities detrimental to the well-being of the animals. The dangerous trend, if not checked immediately and permanently, would lead to an irreversible impact on conservation and protection of wildlife, with a potential threat that in case of a major flood, majority of the internationally acclaimed species, the one-horned rhino, will be wiped out forever. This is a report, independent report of CAG. Well, the fact that Assam government has been sending, we don't want proposals to be sent and rejected. Malad, throughout the country, except Assam and some states, virtually all complied with the direction of the Goa Foundation case of 2006. In fact, the Goa Foundation case came in. In fact, the order which I have annexed talks about the involvement of the then Prime Minister, because the Prime Minister is the chairman of the National Board of Wildlife. They had an action plan called the Wildlife Action Plan for the entire country. Their thing was that the protected forest needs a buffer zone, because that is an area where straight away the construction or the commercial activity starts, the animal needs to have a transition zone. So what they said, if you have not notified it, then you take 10 kilometers to be the the default zone. And on that, you will have to have regulated, prohibited, and permitted activities notified immediately. From 2006, after the Supreme Court's Goa Foundation case, neither the central government, neither the state government, Assam government, I'm concerned with Assam government, did not do anything. It was in 2009, they sent proposals to the state central government. 9 days sent it, nothing happened. 15 days sent it, nothing happened. 18 days sent it, and on 2020, the Central Expert Committee came up to a finding. Well, this is the operative part. The Lordship will come to page 483. Well, the order starts at 467, Annexure K. It is a minute of the 41st Expert Committee's meeting for the declaration of eco-sensitive zone around protected areas, wildlife sanctuaries, and tiger reserve. Our Assam, the Kaziranga National Park is also a tiger reserve in 2007, and zonal master plan. Well, your Lordship will come to the operative part, which is at page 483. Mr. Yadava, Forest Department, Government of Assam, gave a detailed presentation on the proposal. It was informed that the ESZ proposal for Kaziranga National Park was submitted in the ministry on 28 July 2015. After subsequent meetings and discussion within the ministry and by the expert committee, state was asked to revise the proposal integrating Kaziranga National Park and its adjoining 8 PAs, protected areas. It was referred that in pursuance to the Honorable Supreme Court's order of 19 in WPC 202, mining activities has now restricted in Karbi Anglong, adjoining to Kaziranga National Park, and also no new construction, and also new construction has been banned in the identified corridors. The committee pointed out that in spite of restrictions and ban imposed by the Honorable Court, the present proposal of ESZ for Kaziranga National Park has been submitted in isolated form without integrating with 8 adjoining PA. Well, this is the indictment of the Assam government. Further, it was observed that the extent of the ESZ in most of the locations are almost zero, and it is referred as 0 to 6 to 2 kilometers in the draft notification.
The state government's representative informed that the standalone ESZ proposals for Kaziranga National Park is prepared taking into account the observation of the Central Empowerment Committee constituted by the Honorable Supreme Court. The salient features is as given below. Area propose extent 0 to 6.2. The committee members along with NT, that is the National Tiger Conservation Authority, insisted for integrating ESZ proposal with 8 PAs together with reserve forest, as the present proposal may have a long-term negative impact on the entire biodiversity. Central government was concerned of the area and needs protection and conservation at this stage alone only. The chairman expressed the views of the expert committee may be suitably apprised to CEC for making proposal meaningful on the said measures. It has been observed that notifying Kaziranga National Park separately shall result in inconsistencies between the ESZ area of one PA may be contiguous with the other PA. As such, this shall add to the environmental concerns and disputes. Based on the presentation made and discussions held, the committee asks the state government to formulate integrated proposal including all the 8. The revised proposal should be sent to the Wildlife Division and also seek concurrence of the NTCA. Well, what has happened in Assam, one of the grounds which I have urged is a ground which nowhere it has been now examined. The ground of the National Tiger Reserve, what they have done, they have to notify the eco-sensitive for the tiger, because Tiger Reserve is a more wider area than the rhinos. Now there is no management action, tiger management plan. And then management plan is a statutory requirement under the Wildlife Protection Act. In fact, now what has happened, these issues, well, it's good that I've got a document which will help me in this case. The Assam government takes a decision to build a luxury hotel of Hyatt company in an area in Karbi Anglong and Kaziranga, because that is the one of the notified corridors, because these are there for the past 100 years. Kaziranga has completed 100 years, and there the maximum animal corridor is there where movement is maximum from Naugaon as we move from the Bura Pahar. There, the central government has clearly given an affidavit stating that eco-sensitive zone till now has not been given by Assam government. But for the tiger, they have sent it. But they won't allow Assam government to build any structures because that is a core tiger area. Now, this document has come to me because a suo motu application has been taken up by the Green Bench. And this is the affidavit given by the central government about 3 days back. They have made it very clear, will not allow. Because now the permanent structures, if they come out, you first of all don't notify the eco-sensitive zone. You keep
things not a part of the.
It is not a part of, but it brings an issue which has got relevance with my case. I can always later on come up with an additional affidavit.
Okay,
for my argument's sake, I am placing. What I want to show, say, this is a proper area where judicial review, a merit review is required, because the courts, Supreme Court in the Gudamarman case never said the high courts will not take into consideration violations in their own states. In fact, the order specifically says that any order passed by the high court will not be contrary. We don't want any orders which goes contrary to the Supreme Court. We want orders which will be in consonance with the Supreme Court. So what I feel that the fact that this issue has been hanging fire and the CAG report has been totally ignored, the central government's queries have not been met. The Lordship will issue notice on this, because once the notice is there, in fact, the Assam government should collaborate with this litigation, because PIL, the Supreme Court has said it's a collaborative litigation.
Not always, my lord. There are
no
judgments to indicate that by poisa interest litigations are also.
Well, this sort of allegation cannot be brought. My petitioner is quite a responsible.
This is the social media post by the petitioner.
One thing I want to know, the problem with the state government at present is that are they a totalitarian state? Whenever issues of public importance comes before the court, the state government says that why it is submitted in the paper. Well, they should know that in the SP Gupta's case, the Supreme Court, when RTI was not there, talked about open government. If the government thinks that it's a closed government, it's for them. But I personally feel this is a matter which needs judicial scrutiny and notices should be issued. And in fact, from the prayers in the from the petitions, all IA was regarding mining in Karbi Anglong and the elevated corridors, and all the IAs has been disposed of. So I rightly have brought to the notice of this court that the IAs which were learned at 42944, there is no mention of any eco-sensitive zone. There is no case pending in the Supreme Court. I can vouch for it. And in fact, your lordship will find that in the petition, in the order of 2019, I will show what is the prayer in the order of 2019. Yes. Your lordship will come to 124. Well, we are also bringing a case before this court with full responsibility. We also know our limitation. Your lordship will come to page 124.
Just a minute.
Yes.
Just a moment.
Yes, Lord. Hello? Yes, sir. Well, your lordship will come to what was the statutory requirement of the Assam government, which they have remissed. Well, your lordship will come to 112. It starts at 109. Sorry, 107. This is a set of guidelines of 2011, which later today has been reiterated by the Supreme Court. Well, this is a guideline for declaration of eco-sensitive zone around national parks and wildlife sanctuary. For 18 years, the Assam government has been sitting over it and has been sending proposal to a point of infinity. Well, this is a letter from the Deputy Inspector General of Wildlife to the Chief Wildlife Warden. And this has come pursuant to the Goa Foundation case of 2006. Can I read, Lordship? Guidelines for declaration of eco-sensitive zone around national parks and wildlife sanctuaries. Sir, in pursuance to the decision taken by the National Board of Wildlife, all states and union territories government were requested for forwarding its specific proposal for declaration of the eco-sensitive zone around national parks and wildlife sanctuary. Several reminders in this connection were also sent. Honorable Supreme Court has also taken note of this decision and had directed states, union territories, government to forward proposal. This ministry, however, only very few states have forwarded proposal of this to this regard. Well, Assam basically is the defaulting state. This ministry, after careful consideration, has therefore directed decided to frame guidelines to facilitate the state government, union governments for declaration of eco-sensitive zone around national parks and wildlife sanctuary. Kindly find herewith the copy of the guideline. Well, these guidelines were given. I won't trouble your lordship with the guideline detail. The statutory provision is given. Then your lordship will come to an operative part at page 112, the procedure. This is the statutory requirement, what has to be done by the Forest Department. As has been indicated in the foregoing paras, the basic aim is to regulate certain activities around national park and wildlife sanctuary so as to minimize the negative impact of such activities on the fragile ecosystem encompassing the protected area. As a first step towards achieving the goal, it is a prerequisite that an inventory of all the different land use patterns and the different types of activities, types and numbers of industries operating around each of the protected areas, national parks and sanctuaries, as well as important corridors be made. The inventory could be done by the concerned range officer who have a stock of activities within 10 kilometers of the range. For the above purpose, a small committee comprising the concerned wildlife warden, an ecologist, an official from the local self-government, and an official of the revenue department of the concerned area should be formalized. The said committee would suggest the extent of the eco-sensitive zone for the protected areas being considered, the requirement of such a zone to act as a shock absorber, to suggest the best method for management of the eco-sensitive zone as suggested, to suggest broad-based thematic activities to be included in a master plan for the region. Based on this, the Chief Wildlife Warden would group the activities under the following categories of prohibited, restricted, and permitted. In Kaziranga, what has happened? This has never been done. As a result, there is no tourism regulated zone. Anyone can start their hotel industry anywhere. And basically today at this point of time, whatever resorts and hotels are working and dhabas, they are in complete violation of not only the guidelines of 2011, but they are also illegal because they have no permission of the National Board of Wildlife under the Wildlife Act. Because you need to take permission. Because the Assam government has not done that first part of regulating, prohibiting, and permitting. As a result, the land patterns are changing, and the 9 corridors, which has been going on for ages, the animals go in that area, they have been devastated. In fact, there are records in the CAG report which says that tigers, Royal Bengal tigers entering someone's drawing room, sitting there. Because where will they go? Now, our concern is that this statutory duty, which is reposed on the state government, is being completely flouted from 2009. In fact, each government, whatever government had come, had sat over it. And now what has happened? The CAG report is saying that the one-horned rhino will be wiped out because they are now blocked. So this is a very valid case where this court, well, I am seeking a judicial review. In fact, I have called for an interim order that all the inventories of the 9 corridors be given regarding the change in land pattern. In fact, I have given a specific prayer on that. Because until and unless, Lordship? Yes, this is the prayer. Audit finding of the CAG, which has got relevance with my prayer, interim prayer, page 359. Can I read, Lordship? Despite the decision of the National Board of Wildlife in 2002 about creation of ESZ is more than 11 years of the park authorities to draft the ESZ, that is 14 CAG report, and forward it to the PCC of Wildlife Assam. It has also observed that in view of the non-submission of ESZ by the NPWS, the Government of India has been issuing reminders. And in July of 2013, the Government of India informed the state government, including Assam, about its decision that the default zone of 10 kilometers from the boundary will be the ESZ. However, no concrete action was found to have been taken to comply with the GEO's guideline till the date of audit. Meanwhile, the Kaziranga Biodiversity Conservation and Development Committee recommended on October 10 that notices to encroachers on the government land has been issued with bona fide interests before permitting or any construction relating to hospitality sector NOC from the KNP authorities should be called for, which would be communicated within 15 days of receipt. Otherwise, it will be presumed that he has no reservation or objection over the said construction. Number 3, any unauthorized establishment coming up in the natural animal corridor should be stopped and action taken for its removal. All constructions should be mapped and reviewed, and best measures to overcome the problem of animal corridors obstruction should be worked out and action taken accordingly. Scrutiny of records interaction on June and July of 14 with the circle officers in charge of the land falling under the Bokaghat and the Koliabar circles and physical verification of NH 37 revealed the following. The irregularities, encroachment of land falling under the second, third, and fifth additional areas falling under the circle officer Bokaghat has been discussed earlier. Besides the information of status of land under these additional areas enumerated from physical survey conducted by the civil administration in 2009, after which no further survey was carried out, though 5 years have elapsed. In Bokaghat Circle, 29 resorts dhabas has been running for periods ranging for 40 years on land falling within 2-3 kilometers of KNP boundary, majority of which will belong to agricultural class. On this, the two Ikora resort and resort Borgos, the land pattern have already been changed as commercial land from agricultural land. In 5 other cases of resorts, dhabas, namely Bonhobi, Wildgrass, Kaziranga Wilderness, Emerald Hotel and Resort and Ma Kamala Lodge, the application for change in land use are under process in the civil administration. It has been noticed that the Dhansiri Eco Camp has been constructed over 19 bighas, 2 kathas and 10 lechas of government land. Thus, the conversion of land use pattern and further processing of application for conversions are in stark contrast to the affidavits obtained from the purchaser and also decisions action proposed as discussed. In Koliabar Circle, 71 resorts dhabas commercial establishment has been running as of 14. In none of these cases, NOC from park has been obtained, while in a number of cases, licenses were found to have been issued by the Kuthori and the Amguri Gaon Panchayat. It is noticed that 22 of the said units were functioning within 1 kilometer of the park, while remaining 9 were within 3 kilometers. Despite the existence of clear guidelines that no permission of change in land pattern would be issued, the action of the aforesaid Gaon Panchayat was highly irregular and questionable. However, the park authorities remain unaware about such irregular issuance of license by the Gram Panchayats, as the survey report accessed by audit is yet to be collected. Further verification of the report revealed that in 4 cases, government land has been encroached by dhabas, hotels, and 1 resort, namely Wildlife Reach Eco Resort, has been established purely on government land, while 3 cases, Grassland, Difolu, and GL, have been encroached to set up the resorts. As regards the position of the land adjacent to the NH 37, falling under both the circle offices, it is observed that the offices did not have ready database to show the position of patta land, government land, and extent of encroachment. On being requested by the audit, the circle officer assured on 14th that the survey would be carried within 1 month. The officials of Bokaghat stated that it may take considerable time. It was further observed that the park authorities had in 13 carried out a survey of the resorts dhabas, which contain information like name of hotel owners, location, GPS coordinates, rooms, available rent structure. However, important information available in the statement prepared by the circle officer, like the source of license, permission, NOC, and most importantly, whether the units has obtained permission of the park and authorities, were not incorporated by the report. In the report, thus neither the park authorities collected the statement prepared by the circle officer, nor did their statement contain required information, and reports were therefore highly deficient. Therefore, there are 4 designated animal corridors which are used by the animals: the Panbari, the Haldibari, the Kanchanjuri, and the Bura Pahar. Joint physical verification along KNP officials carried out by the audit team revealed there has been large-scale construction of dwelling houses, resorts, dhabas, with substantial spare land retained with guard wall, parking wall, lots on the entire stretch of the highway. The portion of the animal corridors and NH being highlands are also used by the animals for shelter during floods. Majority of those highland has been used for constructions of hotels and dhabas. Hundreds of trucks were found parked in a parking area day and night. During the course of field verification, continuous constructions are also noticed in both sides of the NH3. There are a number of crushers unit. Well, this part is not required because this crusher part has been dealt with. Then at 14.2.9, Lordship will find at page 363, it has been observed that the director in his letter of 14 to the Deputy Commissioner Nagaon has also highlighted the above issue and stated that it seems on the ground that disproportionate land use change has taken place between Jaklabandha and district border of Nagaon near Bagori in the form of commercial establishments, resorts, dhabas, parking slots for heavy vehicles, resulting into severe barriers effect between the floodplains of Kaziranga and high grounds of NH3 and hills in Naga and Karbi Anglong district. Further verification of the team and interaction with various stakeholders revealed that there is a constant mining on the Karbi Anglong side that disturbs the natural movement of elephants which frequent the hills and vice versa. The ever-decreasing forest cover due to the mining, coupled with sound pollution by the machineries in the mining, forces the elephant to enter into human damaging crops. This is the third, gave rise to a claim of compensation which the KNH authorities has to entertain and settle. So the audit report went into this detail, and for 14 years, for 10 years, they kept this under wraps. And now the destruction, because of the delay, the destruction is going on, is continuing. Because virtually it seems that neither the civil administration, and in fact, your Lordship will see that in the Godavarman, when it was started in 1996, it was a case from South India on the Western Ghats, then it moved to Arunachal Pradesh and Assam, and ban was done. And it's a continuous mandamus. It's going on till date. Usually the Chief Justice takes the matter. Well, there, if your Lordship finds that the matters, the entire, whatever forest governance, whatever good has happened because of the intervention of the judiciary. And Lordship knows that the environmental law in India is the creation, it's termed as the judge-made law, because nowhere in the world the judges interpret the law to such an extent because of their creative role, they have protected the forest. And an argument was advanced by my learned friend that today the balance has to be done. Well, the balance is now not economic development. In the 90s, the Supreme Court was in favor of economic development. As a result, dams and all were constructed. Today, in fact, there is a latest judgment by the former Honorable Chief Justice of India, Chandrachud, where he has said that with climate change and forest cover, deforestation and biodiversity loss, the courts now will have to stand in favor of protection of conservation, for conservation. In fact, they have used the word that the anthropogenic activities, they are damaging the entire planet. So now ecocentrism policies has to be adopted. And in fact, whatever protection in Assam, three important issues which we have taken up. One is the Deepor Bill. The intervention of the court has stopped it from being denotified. The Dihing Patkai forest, tropical rainforest, one of the biodiverse hotspots of the world, intervened by this High Court. It has been stopped. The drilling, which I have given this now, Dibru Saikwa, it has been stopped. So these are the areas where, so I'll call upon your Lordship, at least that notices has to go, and Lordship will go for a judicial review or merit review. And in fact, these guidelines, what has happened, these guidelines have been in 179 of the Godavarman case, the first guideline is the page 178. The Supreme Court has said the strict adherence to the OM of 11, which the Assam government till date has not done it for past 18 years. 178, Lordship will find. We accordingly direct, because the Supreme Court was constrained. 178, each protected forest, that is national park or wildlife sanctuary, must have an ESZ of minimum 1 kilometer measured from the demarcated boundary of such protected forest in which the activities prescribed and prescribed. Prescribed, Lordship, is the prohibition. In the guidelines of 9 February 1911 shall be strictly adhered to. We are not concerned with Jamuna Ramgarh wildlife. So in view of this categorical finding and in view of the submission which I made, which has categorically shown that the state of Assam has defaulted in performance of its statutory duty, a judicial intervention is required, Lordship. I call upon urge upon a Lordship to issue notice. In fact, In the earlier cases, the chief secretary was made the party and the PCCF. Now the Supreme Court, after 26 years, have realized that the police will also have to be brought in. The home commissioners are also brought in for compliance. In fact, I have made the home commissioner of Assam also a party. So I urge upon your lordship that notices may go, and on the interim prayer, lordship, at least the status of the inventories of those 9 corridors be given place. That is my submission.
Well, I have small submissions to make. E622 is space 555 affidavit.
126. Starts from 126.
It starts from 1.
No, no, muta.
Oh,
555 of the affidavit. My lord, all these materials, my lord, which are incorporated in the writ petition on merit, my lord, were also available on the date when the Honorable Division Bench of this court, my lord, on the last occasion adjourned the matter sine die. Arguments on merits were made, but we are not opposing the argument on merit, my lord. What we are saying, if you have to make an argument on merit or place something on record, place it before the Honorable Supreme Court. We are not saying that this is incorrect. That will, if need be, my lord, will file an affidavit before Honorable Supreme Court. What I'm saying, my lord, issues raised herein, my lord, ought to have been raised before Honorable Supreme Court. Because, my lord, will see, on the last occasion, when the division bench passed this order, my lord, 24/10/2024, everything were before the Honorable Division Bench. Same submissions were made. Despite that, my lord, it was held. It was their concession also, their submission also, that the issues are already sub judice before Honorable Supreme Court. So today, my lord, if this Honorable Court wants to, my lord, issue notice, take cognizance of the matter, my lord, they have to satisfy, my lord, that some changes of circumstances, some circumstances have changed in the meantime. And what circumstances they are bringing, my lord, they are bringing the last order of the Honorable Supreme Court, wherein that IA pertaining to Karbi Anglong part has been closed. So is it enough, my lord, that Karbi Anglong part has been closed? So the ESZ, which is essentially a substantial issue before the Honorable Supreme Court, according to their own submission before this Honorable Court on the last occasion, my lord, has gone, my lord. There may be several irregularities, my lord. there may be several illegalities. We'll respond to that. We'll correct everything, but not before this Honorable Court. It has to be before the Honorable Division Bench. Sorry, so Honorable Supreme Court. And that was the agreement, that was the order of the last Division Bench. So to modify that part of the order, to issue notice, withdrawing the order of adjournment sine die, they have to satisfy, my lord, the change of circumstances. And what they have submitting, my lord, they're submitting an order of the Honorable Supreme Court in an IA. Main case is still pending. In fact, my lord, today it is again listed. It is listed last order, my lord, which are slated to be listed tomorrow. That is, yesterday it was listed before Honorable Supreme Court. Today again, it has been, this case has been listed. So, my lord, instead of approaching this Honorable Court, my lord, same thing, let them file before Honorable Supreme Court. We'll respond, my lord. We'll respond. The choice of forum perhaps is not correct, my lord, and which was agreed to by them on the last occasion before the division bench, my lord. And that has been changed now.
Well, at a short.
But one small submission, my lord. It means we need long term. But our High Court rules, my lord, for a moment. That if my lord is holding this same book, my lord, then it will be page 491. The rule starts at, my lord, 488. Guwahati High Court Public Interest Litigation Rules 2011. For 88, the rule starts, my lord. I would like to take your lordship to Rule 10 at part 3. Rule 10, my lord. Rule 10, instructions for filing public interest litigation. I will take your lordship to 10G, my lord, at page 491. In para 6 of the writ petition, details of representations made to the authorities concerned for remedial actions and replies, if any, received thereto shall be set out precisely. This is a mandate to file a PIL before this Honorable Court in terms of the rules framed by this Honorable Court. Now, my lord, if we see the paragraph 6 of the PIL, my lord. Paragraph 6 of the PIL, my lord. That's why I was all along saying, my lord, they should have approached the Central Import Committee first, then the Honorable Supreme Court. Paragraph 6, my lord, will see at page 17 of the PIL. So details of representation are to be indicated. It says the petitioner states that Kaziranga was notified as a reserve forest in 1905, a game sanctuary in so-and-so, wildlife sanctuary in 50, national park in 74. That requirement of, my lord, making statement regarding representation and the response has not been complied with by the petitioner. That in fact, my lord, none of the representations have been annexed. Not a single statement made in the PL that they represented before authorities by way of a representation, and that has not been acted upon. There is no whisper to that effect. That means, my lord, they have not complied with the mandate of rule, paragraph 6, my lord, that rule 10G. And, my lord, in that situation, what is to be done, my lord? There is a judgment of division bench of the Honorable Court, my lord, if the rule 6 is not complied with. 2017 2 GLT, my lord. 2017 2 GLT 443. Name of the party is, my lord, Rosemary DZUVICHU and others versus State of Nagaland and others. My lord, initially, my lord, how the rules came to be formulated, my lord, the Honorable Supreme Court's orders, Balwant Singh Chaufal case, my lord, pursuant to which, my lord, rules have been framed. That has been discussed, my lord. And then, if I may take your lordship to paragraph 5, my lord. In the course of time, there has been instances where the Honorable Supreme Court has come across, para 5, my lord. In the course of time, there has been instances where the Honorable Supreme Court has come across attempts to abuse PIL, which by now has become a vital and potent weapon for protecting the rights of the common citizen, especially the downtrodden. Therefore, the Honorable Supreme Court had to introduce remedial measures to curb the menace from time to time, but found those remedial measures not sufficient enough to safeguard its very vital and important system, which has been nurtured, developed, and protected jealously by itself and the High Courts. Therefore, the Honorable Supreme Court, in order to encourage and promote genuine and bona fide PILs, and at the same time to curb the misuse and abuse, had issued the directions in the same case. That's Balwant Singh Chaufal case that has been quoted. In fact, pursuant to that, my lord, this Honorable Court has framed the PIL rules, my lord. That was the judgment of the Honorable Supreme Court. If we, my lord, now come to paragraph 6. Following the directions of the Honorable Supreme Court, this High Court, in exercise of powers conferred under Article 225 of the Constitution of India, has made the rule called Guwahati High Court Public Interest Litigation Rules 2011. Under Part 3, Rule 10 of the said rules, instruction for filing public interest litigation has been provided. At Clause G of Rule 10 of the said rule, it is provided as follows. In Para 6 of the writ petition, details of representations made to the authorities concerned for remedial actions and replies, if any, received thereto shall be set out precisely. According to this rule, it is obligatory for the petitioner of a PIL to give or submit representation or memorandum to the authority concerned before the PIL is filed, in order to give the authority the opportunity to perform its duty. It would be seen in the above stated rule that the word shall is used. In normal interpretation of laws, statutes, rules, the word shall is generally accepted to connote mandatory nature of such rule. Therefore, the above stated rule has to be followed as is written. Paragraph 7, my lord. We have perused all the PILs laid before us, and we have found that in none of the petitions, the petitioners have discharged their statutory obligation as contained in Rule 10G of the Guwahati High Court Public Interest Regulation Rules 2011, which is mandatory. Therefore, we are unable to admit the petitions for that reason. There is an exactly identical case without any representation. Forget about, I'm forgetting about the authorities of the government, be it central or state. They have not approached before the Central Empowered Committee. In fact, there are orders of the Honorable Supreme Court to approach them, try to mitigate. If it is not possible, we'll decide. The Honorable Supreme Court has said. By not doing so, directly rushing to this court without making any representation, they have, besides other grounds, my lord, they have violated this rule also. And my lord, submission have been made that PILs are usually non-adversarial. It is true, my lord. A genuine PIL is non-adversarial. We are not on merit in this case. In this case, we are yet to file an affidavit on merit. I am on the issue of taking cognizance of the PIL by this Honorable Court. Well, the day when I think, well, I must indicate this, the day when the Honorable Division Bench adjourned the matter sine die, it was reported in the front page of Assam Tribune that state government has violated so-and-so, High Court has adjourned the matter. The same petitioner, my lord, in his my lord social media post has posted that government is doing this, High Court is doing that. These are partially, my lord, may not be absolutely, partially public interest, publicity interest litigation, my lord. So my humble submission would be, my lord, instead of venturing into or going into the merits of the case, my lord, let them approach the authorities, at least the Central Empowered Committee and the Honorable Supreme Court, because there may be divergence of orders, my lord. If my lord starts to monitoring, my lord, while it is being monitored by the Honorable Supreme Court, my lord, there may be divergent views, my lord. So it may be either dismissed or not following the PIL rules, and because of pendency of Honorable Supreme Court case, or my lord, it may be adjourned, signed it, and the earlier order of the division bench may not require any modification, my lord. Deeply obliged.
Only short point I want to comment. Well, Lordship will find that the main IA
which was order which was passed in 2019, which I have annexed at page 124, talks about IA numbered as 42944. That is the primary IA. And what was the issue was the Karbi Anglong issue.
In court.
Today, in the
In
order of
case,
20.
we cannot
My lord,
find out.
can I
why
make my
which side is for
submission,
what.
my lord? Sorry, that part has been disposed of on 20th of November. And on that day, I never made a concession. My lord,
It is recorded in the order.
It is propriety demanded. When they objected, I said that, okay, then let us wait. So it is not that I opened up. In fact, he says that on that day, the merit was not there. In fact, he was not there. His junior was there.
It was
So
to
he
be
should make
about to be
submission.
dismissed.
So number one. And number two, PIL is a inquisitorial litigation with a locus standi concept which has been expanded by the court. Even epistolary jurisdiction letters written to the court invokes the jurisdiction of the court. So a doctrinal approach of rules and all will not come in my case. So it's an issue of grave public importance, and I as a journalist found it necessary to bring it before the court. Your lordship will take a call.
By the time we dictate the order, it may be late. Text for the order will be disposed of Monday.
Deeply.
You just give the memos of council present. You have to say anything, Mr. Chaudhary?
No, Lordship, I would go by what my understanding.
Okay.
At this moment.
You're circulating a slip, just note the names.
Yes, well, we'll give them.
Mr. Das, just give the names. We are circulating a slip.
Yes.
Give the names.
Well, there is a judgment of the court where public interest litigation should not be dismissed on technicalities. There is a Supreme Court judgment of AI 1985 Supreme Court 167. Paragraph 38.
AI?
AI 1985 Supreme Court 167. Prabodh Verma versus State of UP.
Pramod Verma.
Yes. Prabodh. BOD. Verma versus State of UP. 85 Supreme Court 167 paragraph 38. Where the Supreme Court has said that public interest should not be dismissed for technicalities. Because it's a white
para.
Para 38.
So blessed.
Item 47 for motion.
Just a moment. Yes.
My lord, on the last occasion on the matter was listed, my lord. My lord has specifically asked me to apprise this court about the 218 of D of the minority judgment, my lord. I have carefully gone through the whole judgment, my lord. 5 judge full bench judgment, my lord. One dissenting judgment, my lord, has quoted on 21H-D, my lord. My lord, I'd just like to read the first part, 21D, in page number. If my book, I'm carrying this book, my lord, if my lord is GLT, my lord.
Give it. Pass it on, pass it book.
I'm sorry, I'm handicapped, my lord. I'm carrying only
It's okay, give that book. Which paragraph you just indicate?
218, my lord. The first, my lord, my respectful prayer will be to read 218, my lord, D.
Yes.
This is what really troubles me, my lord.
Yes, this is, we have seen that.
Yes, my lord. This is one. Against this, my lord, I'll just like to take you to page number 70. The Honorable Chief Justice, page 70. Against on this same issue, my lord, how the Honorable Chief Justice has written this, my lord, page 70, my lord. And then, my lord, my respectful prayer will be again.
Just a moment.
Yeah. There are
You have the book.
yes, ma'am. After 70, my lord, my respectful prayer will be to see 115, my lord. The Honorable
Paragraph.
115. Probably, my lord, with this binding.
Yes, how does it start?
Page 115, paragraph 153. Therefore, based on the aforementioned reasons, comma, we are of the considered opinion that the framework outlined by section 6A is that an individual falling under the category 6 capital A within bracket 2, 6 capital A within bracket 3 can only be assured Indian citizenships. Such individuals are presumed.
This legal book we are not getting it.
Itu all of Milan, numbering to Milan, right? Page 115, paragraph 153.
Can I get started?
itu kitab naik ekai kitab ani silwate, sorry.
There's no 153.
153 there, man.
Oh, acha.
It's divided in 5.
153 is by the Reverend Single Judge, Justice Suryakant.
Yes, my lord. And then, my lord, page 163, para 387, this is 99. Page 115, I'm repeating, my lord, for my own clarity. 153 is the paragraph that, my lord, I like to rely, my lord. 153. Honorable Justice S. Suryakant, my lord. And then.
Yep. Does he? Yes, after 153.
Page 163, paragraph.
No, don't say page number.
Okay, my lord. 387. 387. This is the conclusion, my lord. Starting with drawing upon the comprehensive analysis presented, my lord. 387.
Yes.
And then, my lord, 391. A and B, my lord.
Yes.
Yes, my lord. My lord, this very PIL was dismissed, my lord. 274 Assam Public was initially started in 2009. It was clubbed with 562 of 2012, my lord.
But what is the principle of interpretation? You see, in this paragraph, you are referring to a three.
The first
Number
paragraph,
one.
that 120, then 153, then 387, 391.
You've given paragraph 68, 70, then 153.
First paragraph, my lord, 120. 120.
120.
Yes, my lord. Then 153. Then 387. Then 391.
So you see that observation.
Yes, my lord.
With regard to the date of registration.
Yes, my lord.
That is given by the learned single judge.
Then single judge, my lord.
But if, what is the principle of interpretation? You see, it's a constitution bench judgment.
Yes, my lord.
3, 1 and 1.
4 and 1, my lord.
No. Three honorable judges are given a different verdict.
Yes,
one is concurring and giving its own interpretation. The fifth honorable judge is giving a dissenting judgment. So what is the principle of interpretation? The judge giving a dissenting decision has given a very specific direction, which is not contrary to the finding of the what you call larger bench, majority decision. Then what happens?
In that case, my lord, it was the issue, the validity of 6A, not on the procedural part, my lord, the registration part.
No, procedural part, there is a judgment. Supreme Court judgment, we can't say, we can't just wish that this is what is the issue, what is there, what should be followed. Even a dicta in a particular case would be binding on us.
Since it's a minority, my lord, my respectful prayer will be the issue was the validity, my lord. And then here the issue is on the procedural part, that the late registration or at the validated stage, the registration will be allowed or not. On this specific issue, my lord, our High Court, I have a 7 number of judgment by this on division benches of this, my lord. How in these years, my lord, our High Court has dealt with the issue, my lord. The first judgment that I'm relying, my lord, is Pranoti Bala 2295/14. After 15 years, my lord, it was decided on 15/9/17 and authored by the Honorable Justice Ujjal Bhuiya, my lord. And ultimately belated registration was allowed, my lord. The second judgment, my lord, in the very second page, my lord will find.
No, registration is allowed is different.
Yes, my lord.
That we have also allowed. Even 2 days back, prior to that judgment coming to my notice, we have also allowed. The question is the interpretation of this judgment. And can we take a contrary view? Because very specific paragraph has been given. It's a paragraph devoted to this.
The paragraph devoted and then
it also says the words are that after this date of this judgment,
yes,
it shall not be done.
It shall not be done. The specific, my lord, limit as per the citizenship rule will no longer be eligible for the benefit of citizenships.
It's a specific direction.
Specific direction.
And this direction is not contrary to the directions given by the majority judges.
But here, my lord, in 387 and 391, the language used, my lord, we.
No, we always write we. Even I am sitting in a single judge, there will be hundreds of my orders. You will find I am using a plural, because this is not a judgment of a particular honorable judge. It's a view of the court. Therefore, we always say in plural. Even if I am sitting singly, even in bail matters, you may find when it is authored by me, I may very well write that it is we.
My understanding, my lord, subject to what, my lord, if my lord is interpretation part, interpretation relate to the validity of 6A, my lord. And then here is the procedure that if anything
No,
happen.
don't take us to those things, because you see, we are very candid on this, because we have asked you this question. In our judgment of the Supreme Court, there is nothing which is called unessential part. It is under two divisions. Number one is an obiter, the second is a dicta. And there are authorities, many authorities on the point how to interpret the judgment of the Supreme Court.
Yes, right.
So even a dicta, even if it is not the issue. Even a passing remark under 141 is binding on us.
In that case, my lord, my export will be, my lord, at this stage, my lord, since notice was issued, my lord, in this case. Some deliberation is also required from our side. This was day before yesterday, it was listed, my lord. I have gone through this 401-page judgment.
No, you
And
taken
then-
a job because this is something which is very
my-
clear.
It's clear, my lord.
When we are referring to one judgment.
In that case, my lord, the authorities, the division bench judgment that I have given, my lord, in this 7 judgment, my lord, even after 28 years, late registration was allowed. Before, definitely, my lord, before coming this judgment into effect, my lord.
You know how you know the principles, how we will be interpreting the earlier judgments in view of the recent Supreme Court judgment.
Receipts.
You know the principle, how we will be interpreting. We have a principle which is called it is called implied overruling. That would apply. But we'll take a call. Mr. Sharma, what do you have to say in this? The view of the minority, how should it be read? What is your answer to that?
We are always bound by the apex court judgment, Lordship. Lordship.
Before, if my,
Thank you. Lordship, may I need some Lordship further study of this judgment, Lordship. Can it be on Monday, Lordship?
But it's not possible. Monday, Tuesday, we are facing so many matters.
since it's a larger issue, my respectful prayer will be, my lord. Since my learned friend is also, seeking for some time, my lord. If is doesn't that inconvenience, my lord, my respectful prayer will be.
Any day, Lordship,
Any day.
except today, Lordship.
I have some other judgments, where it said that the conclusion part is not important, my lord. The ratio is important.
Joint prayer made by legal counsel for both sides. List on Friday.
My lord, the judgment that I have given of this honorable court, my lord, division bench judgment, my lord.
We have taken note of this.
Yes, ma'am.
You want us to deal it with now, we can do it.
I do understand, my lord, but my respectful prayer will be, my lord, on it.
Okay, we have adjourned it.
I'm deeply obliged. Okay. I'm deeply obliged.
কিতাপখন আনকচোন 48.
Please, Your Lordship. Lordship, can you take it after some time, Lordship? You know, oh, bless you.
Can you give me some time? 10.
Yes, item 10.
Item 10.
Yeah, as per your lordship's last order, my lord, 18/11/24, my lord. But some updated instructions were called for, my lord, from the state, my lord, as well as my lord, learned CGSC was also asked to give the updated.
May I please, my lord?
information.
I'm
No, no.
giving.
This is, I think, listed for the first time.
It came up, my lord.
It was done.
May I please, my lord?
Final report.
My lord, in this case, I'm preparing for, on behalf of Union of India, as well as for Indian Army. My lord, in this case, certain instruction has been sought by the last order, and I have conveyed that last order to the army personnel. But till now, my lord, I have not received any instructions. I do not know the up-to-date area of this
They
stage.
may be conceding the prayer made here.
My lord?
If you are not getting instructions, that means they are conceding to the prayer.
No, no, my lord.
Okay.
It is not exactly there. I need some more time, my lord. Some more time.
No, but what about the FR? Final report, Mr. You are there, Ms. Das? Yes, you have.
Yeah, in fact, if your lordship.
Well,
will
however,
permit-
my lord, I have taken my stand in my affidavit in opposition.
Yes, yes,
In that,
that
I
is-
have categorically stated that army do not have a very active role in this particular operation.
Oh, no, the difficulty starts from there.
Yes, my lord.
Here, my lord, actually, what happened that Assam police stated, my lord, both were there, my lord, army and Assam police, and
The
now-
government says you are there.
My lord, I'm not exactly aware of what is the latest
But
instruction that has come from.
this case, my lord, army's categorical stand, my lord, they were not there.
No, my lord, we have considered
No, no,
that the superintendent of police of the Kokrajhar police has informed us,
No,
and
you,
accordingly,
you
we
were,
coordinate with
you
them.
are very well present. The
Yes,
affidavit
ma'am.
says so,
Yes, my
that
lord.
you are present.
But so far as the affidavit is concerned,
No,
we did not
it doesn't-
cross the
you
river
see, no,
on the other side.
It doesn't, the story doesn't match after that.
Yes,
Because when you are with when you are with the Assam police,
yes, my lord.
you don't have a choice not to go anywhere. The Assam police says that they have crossed the river, they went to the other side.
Yes,
You can't say that we did not go. Because you could not have abandoned the Assam police when they are escorting you.
My lord, actually, we are escorting them. It is
We
for
don't
them
know.
to take the main lead of the operation.
No. You are always led by them.
Yes, my lord.
It's not that that means they are the pilot.
Yes, my lord.
If you say that that you are leading them, they will be
Yes.
more happy.
No, so my lord, I am just seeking one last
No, that's
opportunity.
okay, but let us see what
Yes, my lord.
Ms. Das says. Right. What about the other case?
68 of
Rani Kuta PS case number 68. What has happened to that?
Transfer to Kolkata PS.
Runi Khata was transferred to
Kolkata PS.
Kokrajhar PS. Is there any document to say that these two things were merged or taken up together?
Audit objects.
CGM Chirang, is it annexed, Mr. Chaudhary?
No, not, not part of the record.
Lordship, I'm giving a copy of the order. My phone name.
Okay. You bring this on record. We are adjourning the matter, but you bring it on record because this is a inquiry. You take a call, and if required, you bring it on record. This is. And what is the status of this? This is ministerial inquiry. What has happened to the present status of this Kokrajhar PS case number 734?
That is all I have received, Lordship, that instruction.
You annexed the final report? Yeah.
No, my lord, here we are doing the pendency only, we came before this only court, my lord.
Okay. But that final report also has to be brought.
If any, my lord, it has been
So they are
submitted.
saying it's there.
My
Yes,
lord.
right.
And
If
scan
they
copy
bring
of
it on
the-
record, then we can also have a copy
Yes.
of it. That is very necessary.
We have to do it because you see, this is it is the nature of habeas corpus. If these developments are there,
Yes,
you have to bring it on record. Otherwise,
The scan copy, my lord, of the.
because if somebody
Case
has
diary.
died, their family members
Yes,
need
madam.
to know about the steps taken so far. Because they may be thinking that the matter is in the High Court and therefore they will get some justice.
Yes,
But if any further delay in the matter would not be
may not be fair.
appreciated.
Case diary, scan copy of the case diary, my lord, because that would show, my lord, like the other cases also, my lord, that whether investigation was done in a proper manner or not, my lord. Otherwise, again, my lord, that might be required, my lord.
Probably. It will be depend on side
But Mr. A. Chaudhary, learned counsel for the petitioner. Also heard. Mr. B. Dekar, learned CEC, appearing for the Union of India. And Ms. A. Das, learned counsel.
Miss M. Devi, Lordship.
M. Devi, I'm
M.
sorry, I was forget. M. Devi, learned counsel, appearing on behalf of Mr. D. Nath, learned senior government advocate for the state. Next one. Pursuant to order dated 18/11/2024, the learned counsel for the state has produced a copy of the written instructions dated 30/11/2024, along with a copy of order dated 30/9/2020, passed by the learned Chief Judicial Magistrate, Chirang, Kajalgaon, indicating that the case record of Runi Khata, RUNIKHATA, PS case number 68 of 2016, has been made over in a seal cover to the Court of Learned Chief Judicial Magistrate, Kokrajhar. She has also produced a copy of letter dated 27/11/2024, issued by the Superintendent of Police, Kokrajhar, comma, enclosing therewith. Enclosures relating to the inquiry report. By the additional district magistrate, Kokrajhar, which is dated 4/5/2017. Full stop. Next paragraph. The status of investigation of Runi Khata PS case number 68. No, sorry, of Kokrajhar PS case number 734 of 2016. Is not available. Therefore, the registry shall call for the scan copy of the record of Kokrajhar PS case number 734 of 2016. From the Court of Chief Judicial Magistrate. Chirang, Kajalgaon. No, sorry, this will not be Chirang. It will be Kokrajhar. CGM Kokrajhar. Mr. Chaudhary, you have not referred to any final report?
No, no, because we filed this case, my lord, initially, after the incident, my lord, when the investigation was going on.
No, it's okay. I'm just asking you,
Yes.
if this, if any final report has been
Yes,
ordered that you are not aware,
not aware.
you're not brought on record,
No.
correct?
Yes.
Okay. You also know information with that. So it is further provided that in the event the just say, they said from the from the CGM Kokrajhar. So we take note of the next paragraph. We take note of the contents of the letter dated 27/11/2024, issued by the Superintendent of Police, Kokrajhar, that in connection with Kokrajhar PS case number 734 of 2016, charge FR number 170/2023, dated 29/5/2023. This paragraph, so accordingly, the copy of the final report with all enclosures shall also be scanned and sent to this court. Next paragraph, the registry shall send the requisition by email to the said learned court, and the learned chief judicial magistrate, Kokrajhar should be at liberty to send the scanned copy of the records of Kokrajhar PS case number 734 of 2016, including copy of FR number 170 of 2023. By email for being placed before this court. Next paragraph. List on
মানে বছৰটো শেষ হৈ থাকিলে আৰু মানসিকভাৱে অলপ মেধাই দিয়া যায়। এইসময় হেৰিটো বিচাৰি পোৱা নাই, এইটোৱেতো 734 হ'ব লাগে, এই দিয়া আছে, এইটো পেইণ্টটো দিয়া আছে। 734
earlier we have stated about the records. You also had the records including including case diary with all documents appended thereto, comma, if available, comma, and then FR. No? Now when to give, because if you give 2 weeks time, it comes very near to the vacation.
As well, Lordship, after
After vacation would be better.
would be better, my lord.
date.
List on 3/1/2024, 25.
Well, only one aspect, my lord. Here, my lord, that Lordship had called for that Kokrajhar case, my lord. That has been lodged against the dead person, my lord. The deceased, my lord. But the FIR lodged by the petitioner's side, my lord, possibly that 68, my lord, Runi Khata, which has been transferred, my lord, as that instruction.
Would be merged.
Whether merged or not, that possibly, my lord, I may be wrong, my lord, because that FIR, my lord, that was against a dead person, my lord. So that will definitely end in that manner, as we have seen in other cases, my lord. I may be wrong, my lord, whether that has been amalgamated.
We don't know, because there's no order. The only order is available
Transferred.
of the CGM transferring.
But possibly, I mean, but transferred and tagged out, that is, nothing is there, my lord, possibly, my lord.
But that number you have given is mentioned by Lordship.
68, it has been transferred to Kokrajhar, but renumbered, and nothing is there, my lord.
No, but the other number is mentioned in the order.
That order, my lord.
Are there multiple FIRs lodged for this?
There are 2 FIR laws.
We, the petitioner's side, my lord, being the victim side, they lodged one FIR. And the Assam police, my lord, they stated that some, that.
Yes, then right.
My lord, that-
One more paragraph is right. Where we have stated about the transfer of case. Transfer of that Runi Khata PS case. Yeah, after that you write. Accordingly, the Superintendent of Police, Chirang, shall inform the court as to whether on receipt of the records of Runi Khata PS case number 68 of 2016, which case has been registered, and the court where the said matter is where the records would be available. Next para. In the event the records of Runikata PS case number 68 of 2016, as renumbered under Kokrajhar Police Station is available in the records of the Chief Judicial Magistrate, Kokrajhar, a scanned copy of the said records shall also be sent to this court. In second order, okay. So okay, then
Two versions, madam, that's fine, madam, two F5. Oblige.
just like last before you last one, the
732.
732 to 3. What is this? 68 was a running.
Only could have been two. You have mentioned only two FIRs here in the.
Yes,
Yes.
Petition.
one FIR lost by the petitioner's side.
Okay.
This is side, my lord.
Okay, how many people had died?
One, my lord.
Only one.
One.
But there were two FIRs lodged. So every likelihood that they
Yes.
will be merged.
Yes, madam, there is a very
Every
strong
likelihood that
possibility
will
of
be
But
that.
possibly, madam, I may do, because
I
versions are.
understand you are saying that the
How
one is
can
your
the
FIR
accused-
and second is the FIR by the
Yes,
police.
yes, how can the accused, one side is the accused in the other case, my lord?
There has
Okay,
to be a
we get
common
it.
investigation
We
in
get the
this
point.
matter.
No, there has to be independent investigation, possibly not common, possibly, because it has to be
Uh,
independent
the
investigation.
Copy of
Because police
communication
personnel are
dated
involved.
27/11/2024 and 30/11/2024 by the Superintendent of Police, Kokrajhar and Chirang respectively are made a part of record. Okay.
Much.
Deeply obliged, madam.
P1/25.
Time being item 48.
Expertise judgment case 43. After filing the WS lawsuit,
Will call for the records you pay for bill will be considered on receipt of the records. There's a default on your part.
lawsuit, actually lawsuit, I have issued in paragraph 5, 6, 7. and
It's okay, but it's an ex parte opinion of 21.
Lordship, actually, the conducting council expired during COVID period, Lordship.
No, it's okay, but
Immediately after passing the judgment. So
but
there
the
was
negligence is apparent. I should have prayer only on receipt of the record. Heard Mr.
yes,
S. Alam, learned counsel for the petitioner. Also heard. Was there for Union of India? I forgot.
Lordship, S. Purva.
Mr. S. Burma, then CEC for respondent 1. Mr. G. Sharma, Learned Planning Council for the FT matters representing respondent number 2, 4, and 6. And Mr. H.K. Hazarika, Learned Government Advocate, appearing for respondent number 3. And Mr. H. Kudi on behalf of the Learned Council on behalf of Say Harris, Planning Council for respondent number 5. So, you take the format by so and so. Petitioner has said, where is the opinion? Which page?
Page 43, Lordship.
40?
3.
Page 42, 43, no? Yes, say the opinion dated
4/3/2021.
4/3/2021 passed by so and so in case number so and so, arising out of CE number so and so, by which the petition was declared to be a foreigner of post 25/3/1971.